All right, at 6:30, I'm going to ask our Vice Chair, Fearless Dan, to lead us in the Pledge of Allegiance.
Please stand. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
All right, it is December 18th, 2024. This is the Harpswell Planning Board, regular December meeting. We have 4 items on the agenda, and I call this meeting to order. I'd like to declare a quorum and have the board members introduce themselves, starting with Lori.
Lori Rice, Great Island.
Howard Levitan, Oars Island.
Amy Heibel, Harpswell.
Dan Holbeck, Orr's Island.
Christine Donovan Hall, Oars Island.
Matt Gilly, Cundy's Harbor.
Courtney Snellings, Oars Island.
And I'm Matthew James, the town planner.
All right. We have a quorum. Christine is our associate, and at least for the time being, so she will not need to vote, but she is absolutely welcome to ask questions, make points, and contribute in any way she sees fit.
Thank you.
All
And
right.
Matt, too.
And that too.
And
How about
Matt,
Matt?
too. Yeah, I just think you're already, you,
can't
both of the
leave us,
Matts
Matt.
are moving on.
Well,
Yeah, Matt, too.
that might be happening.
Okay.
If his signature-
All right, so we have the introductions, and our first item of business is Robert Gierkink and Diane Plord.
See, they're in a bad spot.
This application has been before the board in November, and I was out for surgery, so I'm going to ask Matt to just update us on what's going on, and then I don't want to put Dan on the spot, but he was chairing the board while I wasn't around, and you all know more about this application, at least the history, so feel free to chime in. Go ahead, Matt.
Yeah, so this application was here last month. The applicants are looking to put a small pier, ramp, and float on their property. There was previously a pier, ramp, and float on the property. And the original application had, there was some confusion as to whether or not they, I think I'm looking at the right one here.
Yeah, whether there had actually been something there
Right.
before.
Yeah.
Yeah.
So we didn't have any clear explanation at that meeting of what the previous ramp and float had looked like or where it had been. So we did request that the application be tabled in order for us to gather a bit more information. There were also some concerns that the area that they were looking to put the float would be interfering with some fishing channels. And that concern was raised by Matt in particular. So I have talked with the harbor master and applicant, and we have gathered up some more evidence in terms of historic photos, both from the ground and satellite imagery. And the harbor master has indicated that the proposed pier, dock, and ramp and float will not interfere with any fishing.
Okay. Matt, is this proposed new design a replacement of the old existing or the old dock, or is it larger?
It is, the applicants have said that it is the same size.
Okay. And I noticed that there were photos in the application, but they weren't dated. So it would be good just for future reference to date photos.
We do have the satellite imagery that has been
Yeah.
gathered is dated by the year and month and day. And I have gone through and with the measuring tool, which is not 100% accurate, but it appears that the proposed dimensions match up very closely with what previously existed.
very helpful.
We're the applicants. We have dated photos, if that's helpful. The same photos we have dated.
Oh, okay. So what I'd like to do now, since you're here and you've taken the time to come, if you would like to say anything, we'd welcome that, and then we'll have the planning board ask questions, and then we'll take some action.
So I'm Rob Geerke. This is my wife Tia, and we are the applicants. We purchased the property 17 years ago, and it had a dock, and we immediately purchased a ramp and float, and it's been deployed every year for 15 years until the dock got washed away. I did send to Matt, I don't know if you received it, I sent some supplemental information, which includes dates to those pictures, I think, that you have, which are of the actual dock, but also invoices of us having the ramp and float taken out and put in every spring and every fall. And in the satellite imagery is stuff that I got from Google Earth, which is, they have a way back feature, which you can look back for several years. But we've put it in every year until I think my wife and I watched the videos of the last meeting. There was concern that we hadn't been using the dock, but we have every year that we've owned it until it got washed away.
Okay, thank you. I'm sorry?
During the summer months, but you weren't showing the photos with the.
Yeah, would you like to see the photos with dating on them?
No, well, if anyone would, that'd be fine, otherwise I'm fine.
Or the invoices with, okay.
I will just say for the board, just so you know, the board receives a lot of applications for docks, and we are a fishing community, so we do pay special attention. It's nothing personal at all. We're just doing our due diligence for the environment and for the fishing community, so,
Right.
you know, it helps everybody when we do that. So we thank you for your patience and your providing the information.
Great.
Okay. Any questions from the board?
We have the approval of the harbor master?
Yeah.
Yeah.
Yes.
It's in the packet there.
Yeah.
We
Yes.
do.
It's on the back.
That was the main thing I thought we were
Yeah.
working for.
Yeah, it's on the back of here.
As opposed to
Yes, it's in there.
guessing. Yeah, no, I think I saw that.
Okay.
Thank you.
So Dan and I spoke briefly this afternoon, and he brought something up that had been brought up in our workshop, which some of you were at and some of you weren't. And it was regard to approving these kinds of applications and our need to make Mr. Plummer or his replacement, but hopefully it's Mr. Plummer, make our approvals contingent upon his approval. And that in future applications like this, we really need to take the effort to do that. Do you want to add to that?
Well, yeah, the concern about whether a proposed dock, particularly where one was not there before, what effect that might have on fishing. And, or on other things shore-related, eelgrass, for example, something like that as well. And that's something that we really haven't put into it, but after it leaves here, the harbor master does have an opportunity to weigh in on it. And so we just wanted to, our whole goal is to make sure that there are no surprises coming down the road.
Right.
So that's the reason for the discussion.
Yeah. Okay, thank you
Okay.
so much. All right, I'm willing to entertain a motion. Anybody?
You're going to start with the
Oh,
conformance?
I'm sorry. Well,
You've been gone a long time.
I know I
haven't
have
you?
been. Okay, so there are findings that the planner has prepared for us. And this, I am always a little, I'm always unsure about how to move forward with these, but he has prepared motions for us. And this is, I move that the planning board finds that the application of Diane Plord, representing Robert and Tia Gerkink, for the construction of a non-commercial residential wharf on Lot 26 on map 66 meets the requirements of section 15.3 that are applicable to the application based on the following findings that are incorporated in this motion by reference. And this is where because the board has done this differently since it used to go through 45 minutes of repeating every single finding and all the language that was in the finding, because the town attorney told us that was what we needed to do. So we've tried to shorten it. But the findings are that 15.3.1 is met. The finding is that 15.3.2 is met, that 15.3.3 is met, that 15.3.4 is met, that 15.3.5.1 is met, 15.3.6, 15.3.7, 15.3.8, 15.3.9, and 15.3.10, and 15.3.11, and that's 15.3.11.1 and 15.3.11.2. All those findings are met by reference to the findings in this document that is dated 10/16/24, and it's item 24-1002. So all of the findings are met, or all of the findings are that the application is complete and that the regulations are met. So I will entertain a motion or make a motion myself unless there's any questions or any comments.
I think you can make the motion, and then I'll second it, and then we'll
I'll
have
ma-
any discussion.
I'll see, thank you, Mr. Lawyer. I will make the motion that we approve this application. Now, are there any comments?
I'd second it.
Are there any comments? Thank you. Okay, I'll take a vote. All those in favor? All right, thank you, unanimous.
You better do the conclusions of law now.
Pardon me?
The conclusions of law.
Oh, the conclusions of law? Do you want to do that?
I can do that.
Okay.
I move that, in light of these facts, with consideration given to the supporting documentation in the record, that the planning board reaches the following conclusions.
I didn't have that.
The planning board finds that the applicants, Robert Gerkink and Diane Plord, have met the standards of the town of Harpswell shoreland zoning ordinance for the installation of a dock in the Resource Protection District. The planning board approves the application subject to the following conditions of approval. One, this application, or this approval is not final until such time as the notice of decision has been signed by the chair of the planning board. Two, this approval is based on the application, including all submissions and information provided by the applicant at final approval, whether referenced in any findings or conditions of approval. Three, the approval is dependent upon and limited to the proposal and plans contained in the application and supporting documents submitted and affirmed to by the applicant. Any variation from the plan, proposals, and supporting documents, except de minimis changes as determined by the town planner that do not affect approval standards, is subject to review and approval of the planning board prior to implementation. The applicant shall comply with all state and federal rules and regulations that apply to this application.
And that is 24-1002 dated 12/18/24. I was reading from the wrong document. Thank you, Dan.
Second?
Are you seconding your own?
No, that was my motion.
I second your motion. All those in favor? Thank you. And I'm assuming there's no discussion. Okay,
Thank you very much.
thank you. All right, item number 2, construction of a residential wharf. Again,
Thank you. Sorry for not responding to your voicemail.
hopefully I have the right paperwork in front of me.
This is our second
Chickens
one that
boil
we
a
talked
hatch, or whatever it is, I don't know the sayings.
All right, this is item 241101, Lawrence Hegarty, who's the owner, and Diane Plord, who is the applicant. This is map 7, lot 151, 309 High Head Road. This has been, again, this was before the board in November. There's a lot of discussion about this particular application. I'm going to ask the planner to give us a summary of where we are, and then we'll take action from there.
Yeah, as Amy said, this is an application that has been before the board before. These applicants are looking to put a non-commercial dock on their property. And at the last meeting, it came into question whether or not this development that the property is part of a subdivision or not, and whether or not a certain standard in the shoreline zoning ordinance would preclude the applicants from building a dock on their property because it isn't a subdivision. There's a few memos that I wrote for that meeting indicating that the property is not part of a subdivision as defined by state law. Unfortunately, we didn't really know where that left us for being able to approve this application or not. So it was requested that we seek legal counsel on the matter. Unfortunately, our legal budget is zilch at the moment, so we had to contact Maine Municipal Association's legal services. They did reply to our questions and said that although it is not a subdivision as defined by state law, it is to be regulated as a subdivision still by the planning board. I asked if, in that case, would this standard in the shoreline zoning ordinance that says that no property that has access to a community dock on a recorded subdivision plan can have a personal dock. I asked if that standard would still be applicable in this case, and MMA said yes. My draft motions indicate that the board should deny this application on those grounds. However, I was frankly confused by MMA's response. They did not offer a clear explanation as to why it would still be regulated as a subdivision. I would entertain seeking further legal counsel so that we understand better how to enforce this and how to discuss this with the public. There are other properties in the High Head community that do have their own personal docks. Not all of them have been specifically listed on a recorded subdivision plan as defined by the law. But in this case, there is some questions, so seeking further legal counsel may be able to clarify that if the board would be more comfortable. If you are comfortable with MMA's response, then we can deny the application. But I will leave that up to you.
Okay, thank you very much. I read the MMA response as well, and I would just add, two wrongs don't make a right. So the fact that other wharfs were approved because the codes office was understaffed and wasn't able to do its job adequately and the planning board didn't know doesn't make that right. But we have two legal minds and we have other very sharp minds on this board, so I'm going to open it up to the board for questions,
Should we
comments.
hear from the applicant first?
Well, we certainly can.
Is the applicant here?
Yeah.
Okay.
I know he wanted to make
Yeah, I do.
bring some things up to us.
Yeah, so last month, the question was whether it was a subdivision or not. And I think the town planner didn't think so. And sure enough, the attorney from the state said, absolutely not, it's not. They're very clear about that, right? But they still said somehow that it's regulated. But I think that's understandable. From the state, I believe there's almost 500 municipalities. They don't know the laws of every municipality. But if you go to the Harpswell website, you can find our subdivision ordinance. And I printed out the page, and it's very, very clear. A subdivision is defined as being an MRSA subdivision. That's what makes a subdivision in the Harpswell ordinance. We're not that. So it's pretty clear. In addition, I looked on Google Maps and counted about 15 docks, and I know there are more from having been out on the water around High Head, 15 docks in High Head. So that means 15 times at least applicants have come before the board. 15 times the board has said, no, it's not regulated as a subdivision, and we approve it. So there's a lot of precedence for approving this. There's also a very clear explanation of why the subdivision rules don't apply right on the Harpswell website. That's my case for getting it approved.
Okay, thank you. And does anyone have any questions of the applicant?
Is there anyone else from the neighborhood who was there or who wanted to speak to this before we bring it to the board? Okay. Howard wanted to say something.
What would I do without you, Dan? I just don't
It's
know.
like a little imp in
I
your
know.
ear.
Yes,
And the Grinch.
it is. Okay.
Obviously, I've been involved in trying to figure this one out for a while. I don't know whether the MMA advice is correct or it's not correct. But I don't think you need to go that far to determine whether it's a subdivision or it's not a subdivision, because you have to look at the plain language of the ordinance. And the ordinance says, doesn't say just subdivision, it says subdivision plan, a recorded subdivision plan. In this particular case, for whatever reason, this property in 2019 was approved by this board for an amendment in order to swap some land boundaries. For whatever reason, it had probably nothing to do with anything other than the lot that already had a house on it at that point, and then this particular lot had a buildable area. I don't think anybody was thinking about docks at that point. But Al LaGrue signed a subdivision plan that says this is an amended subdivision plan. It was recorded in the Registry of Deeds, and the language of the statute says that no new wharf, pier, or dock shall be constructed on a lot shown on a recorded subdivision plan that has deeded right of access to a dock. No question, there's no question about the latter part of that. It has rights 2 lots down to a very large community dock. And that's part of the deeded rights of the full High Head development. I happen to have been practicing law in 1971, when the subdivision law came into effect. It caused great consternation in the legal community because no one knew what it was all about. But in the years leading up to that, a subdivision plan was required to get it recorded, from my understanding. And whether you called it a subdivision plan or not depended on a lot of different things. And each town had different practice on that. But the general theory in Maine was that on the 3rd subdivision of land from a lot, you had to record a plan and in this particular case for High Head, for some reason that is unknown to anyone, the selectmen signed that plan in 1968, 65. And whatever legal effect that has. Thereafter, we didn't consider it a subdivision, but there have been subdivision amendments since 1971, including one that the High Head Oregon Association did in 2020 or 2019.
I believe so.
Yeah, 2020. also resulting in an amended subdivision plan. I don't think we have to reach the question of whether or not this is subject to the subdivision, our subdivision law, which is the state subdivision law, or whether we made a mistake in approving docks in the past. Remember, those docks aren't the same situation as this dock, because those docks, and I don't know how many amendments there've been. I thought there were only 4 amendments to through the Subdivision Act. Those docks were on land that was shown on a plan that predated the subdivision law, and therefore, this provision probably didn't apply, or no one would have figured it out in any event if it did. The only justification that MMA comes up with is a Superior Court case in Kennebec County, I think, and it's not published, so you can't read it.
Yeah,
I tried to find it.
no superior court cases from before 1990 maybe are available publicly online without
Right,
requesting
so
them
it
specifically.
may exist, and it may exist in a treatise somewhere where she picked it up, but we don't know what it says, so we're not gonna be able to figure that one out. Maybe Amy, our town lawyer, could figure it out, but I don't think there's any need to figure it out. The issue is, this particular lot was changed, took advantage, the owner of that lot at the time, not this gentleman, but the person who sold him the lot, took advantage of it, of the subdivision law in Harpswell, and filed an amended subdivision plan, which was approved by the planning board and recorded. That, to me, is enough to make it fall within this section. Regardless of what other subdivisions might have to go through, whether they predated it or not. If they don't, if they're subsequent to 1971, they clearly have to file an amendment in order to do what they did on this particular lot. He took advantage of that, the predecessor, and it is now subject to this particular part of the statute, as far as I'm concerned. I don't think we have to reach the other questions.
Could I comment on that?
Sure.
I mean, I think it's not correct to say he took advantage of. I think nobody understood. And so when they wanted to change the line, they thought they had to, they thought there were a subdivision. It wasn't a question of taking advantage of it. But in addition, when I read what the state attorney said, she was very clear that that didn't make it a subdivision, right? Isn't that what she said? No, it does not. So we have firm no's from the municipal, from the state municipal law office saying, no, that does not cause it to suddenly become a subdivision. For one thing, you have to have at least, I believe, 3 properties to be a subdivision. So that would be my argument, it's not a subdivision.
Aren't there more properties than 3
There's
for the High-Head
It's a
Company?
70 lots.
Yeah, there's,
Right.
in the community,
I mean-
but this was done before 71, and so
That's-
what is the argument? That one border changed incorrectly through the subdivision law, made everybody a subdivision? But the attorney said no.
Well, the interesting thing was, I was curious about the use of the term subdivision, and so I looked it up to see when it was first used in the state of Maine. And that was, I believe, 1971. The High-Head Company was put its land together or whatever in 1965. But basically, to me, it seems like it's a subdivision without the term that wasn't adopted
It's a
until
community, but
1971.
legally, it's not a subdivision according to the state.
But what
Well, the
I'm hearing-
state is very clear. It says this doesn't apply to anything before 1971. I mean, they put that in there. It's not just,
No, she answered the question about whether the development was a subdivision, and she answered that, no. I agree with that. It's not a subdivision as defined by the subdivision statute. But that doesn't mean that your lot isn't subject to this provision.
I thought she said no to that as well. The question was asked.
Did
Did
the
anyone else
Highhead
recall reading that?
Association
I
itself
thought she said it
not
had to
call
apply to
itself
the
a
Harpswell.
subdivision?
No, she answered the question, would the existence of approved subdivision amendments retroactively make the Highhead development, the whole development a subdivision? She says no to that as well, and I
That's,
agree with that.
that's the one I'm talking about, so
But
it's
that doesn't mean
clearly
that
not a
your
subdivision.
lot isn't subject to this law.
A subdivision has to have at least 3 properties. And so the whole of High Head, she says, is not a subdivision. Now we're arguing that I'm a subdivision?
No. You are a lot shown on a recorded subdivision plan. And that's the only thing that needs to happen to trigger that section of the law. You do not comply with that section of the law, as far as in my opinion.
My understanding of the definition of subdivision is it's got to be at least 3 lots.
That, I think you're talking about two different things. You aren't creating a subdivision yourself, you're a single lot, but you are part of a subdivision.
What are the other lots in the subdivision?
The other lots are actually the lots that the Highhead Association actually declared a subdivision. Did the Highhead Association not itself declare itself a subdivision?
Yes.
Yeah.
It filed its own subdivision amendment on another lot,
Subsequent to,
subsequent to this.
I mean, but
right, okay.
she is saying that these changes later don't make us a subdivision, right?
I'm not sure she is, and it does strike me as interesting that the Highhead Association itself calls itself a subdivision.
Well, everybody uses the word subdivision pretty loosely, right? We all use it, but we don't necessarily mean the legal one, but the legal term is pretty clearly defined.
But she
Yes.
does say in here, the subdivision does exist, so therefore the ordinance you're describing does apply to any property within the subdivision.
Right, but that she doesn't give any evidence for, any explanation for.
We have another
Where she's-
question from the Vice
sure.
Chair, please.
Yeah.
Sure.
Yeah, I read that memo as well, and she came to some conclusions that really she didn't give a whole lot of support for. My question is this: either at the beginning, when this whole area was developed, it truly was a subdivision but wasn't called it, or
A
when the
legal
am-
subdivision?
No, just going back to 65. Okay, when that was formed, was it a subdivision or not? It certainly wasn't called one because there wasn't a statute calling it a subdivision. So at that point then, we've established something that was not called a subdivision. Subsequent to 1971, there were some changes which may or may not have erroneously referred to this as a subdivision. So an error occurred at one place or the other. Either it was a subdivision originally, even though it was a de facto subdivision at the time this whole area was laid out, and then everything subsequent to it is a subdivision, or it is not a subdivision, and the changes that occurred were erroneously described as amendments to the subdivision. And I guess where I guess I may be coming down on the opposite side of the coin from Howard here, thinking that the fact that until the changes were made subsequent to the enactment of the subdivision control ordinance, this wasn't a subdivision,
Right.
which means that anything that occurred later does not affect its original status, and therefore the subdivision rules do not apply here.
That would be my understanding.
That is the way I'm kind of coming down here, and I think the fact that all of these other docks were approved in this area were operating under that same thinking.
Some just a few years ago, 2,
Yeah.
3, 4 years ago.
So, so at this point, you have, are you still active or are you retired?
I'm active.
Oh, okay, well then you win, I'm retired. But we've got two lawyers here taking opposite positions on this thing. And an opinion from the state, which I don't believe is helpful at all. So I don't know where that leaves us.
Well, Matt has a question.
I'm not a lawyer at all, I'm the furthest from it, I'm a commercial fisherman. But maybe Howard can answer my question. When they move the lot lines, would filing it as a subdivision made it easier to move those lot lines than if it wasn't, say it was just in the shoreline residential? Was there any advantage per se to declaring, you see what I'm asking?
I don't know why they did it. Let me finish that.
Sure.
I think that they may have gotten advice from the planner that said, and that's from my understanding of what the previous planner had said, he thought that was the best way of approaching it. And so he may have suggested that as the way of doing it. The MMA position is broader than that. It says that even if you have a pre-existing subdivision, in order to make changes in the lots, and you need to do it via amendment to a subdivision plan. There are other ways of changing a lot. You use a meets and bounds, a boundary description, and you change, you swap. You deed one section, and the other one gets deed the other one. And the problem is that the registry is so used to now receiving subdivision plans, because it makes it easier to describe the property, because it's lot X on a subdivision plan as opposed to one course to, going around the perimeter of the thing using directions and meets and bounds, they call it.
My understanding was that
You could have done it that way, though.
that Matt Wogan, who made the change, was led to believe that he had to do it the subdivision way, which really gummed up the works. My understanding is if you're just doing a simple line change and it's not a state subdivision, you don't need to come before the planning board even. So it would have been easier had he thought he could do it the correct way.
Nonetheless, he did it, he
did it.
did it.
Can
As
it
a
be
subdivision.
refiled?
Yeah.
I mean,
Can it get refiled or something like that? Once it's recorded and done, it's cannot be
It's
changed?
done, yeah.
Okay,
And he's received a deed of that lot,
Okay.
and that's all he owns.
Okay. So what we have, in addition to, there were a couple of different ways to doing it. It was done following a subdivision type procedure. The fact remains that as far as this town has been concerned, when other applications for lots have come through, it was treated as though it is not a subdivision.
No, I don't think we know any of that.
I don't think we do either.
I don't think we know that. I think we know that there are docks.
Okay.
We don't know what the process was, as a matter of fact, I don't even know that we know when this section came into being. You'd have to trace this back, but this is not in the state subdivision law. This is a unique provision here
What,
in Harpswell.
what specifically are you referring to, Howard?
The section
Community
about
dock.
giving,
Community dock.
if you have a community
Oh,
dock.
yeah, I know, I live in a neighborhood with that.
Right.
Yeah.
Yep.
So that's a unique thing to Harpswell.
Right.
That is not in the standard, in the subdivision law that the state guidelines say we have to pass. It's one of those local options.
May I
Yeah.
ask Matt if he looked at any of the other docs that are in existence to see if there's anything in the file?
I haven't seen anything. I wasn't aware of anything being done with the other docs. I haven't looked at all of them. I know that the code office generally will do a brief review to see if something is a subdivision before providing a permit. And one of the ways of doing that is looking at the tax maps and seeing if it is part of a numbered subdivision or not. Generally, ones that were large developments prior to 1971 are labeled differently than ones that are created after 1971. I did have, one question that I have that's made me confused is that generally we refer to section 4401 when discussing subdivision law. That's the definition section of the subchapter. But the subchapter also contains an exceptions section. And it says that the subchapter does not apply to previously approved subdivisions and proposed subdivisions approved by the planning board or the municipal officials prior to September 23rd, 1971, in accordance with the laws then in effect. It also says that for previously existing and previously recorded subdivisions. So the 1965 plans, regardless of whether or not they were signed by a planning board or by, in our case, the select board, it seems like section 4402 of the subchapter implies that they would not be subject to state subdivision law. But I do agree with Howard that regardless of those facts, this application is for property that does in fact show up on a recorded subdivision plan. The Registry of Deeds does not look at the files that come before them for accuracy. They do not fact check anything, they just record it. Once it's given to them, they put it onto the registry and that's that. They don't ensure in any way that those items are 100% accurate. So whether or not this was submitted in error or was approved in error is seemingly inconsequential to the specific standard that we're reviewing here. Whether or not we feel that is how things should be done might be a question for a workshop rather than right now. So again, I'll leave it up to you to
Well, there's a
determine
couple of
that.
things that, depending on which way we go on this, there is, he still has a right to go to the appeals board on the
Yes.
fairness issue. That's not a issue that we necessarily deal with. The fairness element is, listen, Harpswell, you approved all these other docks in the High Head lots, and, how can you not do this? This is, it may reach to the hardship level. They have different standards, though, and they may not want to touch this one, or they may kick it back to us. But ultimately, we're the ones that interpret the statute. If we're wrong, a court's going to tell us that.
What I'm hearing, and I'm not a lawyer, but I read the MMA response and I've listened to both of you, and I really feel like we could go either way here. And what kind of bothers me, it doesn't kind of bother me, it bothers me, is that the town, because of its budget, can't afford to go and actually get, I'm not calling MMA anything but helpful, but its own legal counsel to actually give us more solid advice. I think that is not in service to the applicant, and it's not in service to the planning board.
I agree.
Does the money kick in after January the 1st?
No, after the town meeting.
Yeah. it's
Oh,
after
good Lord,
town
we've
meeting.
used it all?
Yeah. So, I have another question. Matt, have you discussed with the town administrator or the select board? I know there's a contingency fund.
I have to say, I was disappointed when I was notified that she was not going to be sending it to the town attorney. It was rather late in the process. I tried to get this question out as soon as possible after our last meeting, and I waited around for a few weeks for a response to find out that she had never sent it, and then requested that I send it to to MMA instead, or she would send it on my behalf. I had to then change the questions so that they would be more appropriate for how MMA requires you to submit questions, and then had to wait for a response from that. They did say that we can ask them again with more specific questions and provide them with all of the deeds and plans and everything else, but I simply haven't had time to gather a dozen documents to attach to an email and come up with new questions in the time frame that I was given from the town administrator and MMA. So in order to get it here for this application, as you can tell, I'm frustrated by this as well.
Yeah.
And really, I could go either way on this as well. This is an issue that I've spent many hours trying to figure out, and I've asked other planners, I've asked MMA now, I have talked to the administrator, I've talked to codes, and I think just about everybody thinks this could go either way.
Yeah. So it seems to me like we could deny this application, and then we could end up having to defend our action against a legal suit, in which case we'd have to ask the town attorney to defend the town.
And then they have no choice.
Right, and then we have no choice. Or we can,
Well, it doesn't get to a lawsuit. He has to take it to the Board of Appeals first.
Well, yeah.
well, yeah,
Yeah.
but you know what I'm saying.
Yeah.
It could get to the town attorney either way. But I feel like we should ask the town to, find the money to ask the town attorney.
Yeah.
Because it's, you're not gonna be building in the next 2 or 3 months. And I think we need a definitive answer. And in part, it's because if we end up saying that it is correct that you should be given approval to build this dock, every other person on High Head is gonna wanna build a dock, and we're gonna have to say yes. This sets a precedent to a certain extent for the board. And I
But
think it's
why would that
worth,
precedent matter and not the precedent that 15 have already been done?
because the board is doing its due diligence, that's why. And if we had more information about how those other projects were approved, that might change things. So maybe we need
I'm
to have
just
time to
curious.
do more research.
I don't know anything about it, but would they have all come before the board?
That's a good question. They didn't come before the board when I've been on the board, and I've been on the board for going on 5 years now. So, no, not that I can recall.
Does every wharf pier come before the board?
Yes.
Wait a minute, where's Margaret?
No,
Do all residential wharfs come before the board?
it
No,
doesn't.
course
okay,
not.
no,
No, they
okay.
go to the select
There we go,
board.
thank you. I stand corrected. But I think we need to do more research, because it behooves us to, we are a fishing community, we guard our shoreline really carefully. Once eelgrass is gone, it's gone. That eelgrass provides seedbed for all kinds of critters that fishermen
Sure,
depend
I
on.
understand that, but I think all that has been vetted already, right? There's no
I
issue with,
don't think that it has, sir.
It
I'm
has,
not
I think.
sure. I'm
yeah,
not-
it has.
Yeah.
I'm not sure it has. I think we need to ask the town attorney and do more research. I really do.
I feel more.
And I'm getting 2 attorneys who are giving opposite points of view here.
Yeah.
So has it been
Well,
vetted?
Yeah, but.
I don't know.
That's the nature of the beast. You have 2 attorneys, you're gonna
Yeah,
have 2
well,
different.
that's
That's
true,
right,
too.
yeah.
Well,
It'd be really scary if we agreed.
Okay, so
But-
that's,
But if I may, so we're in a position now where the regulations, our ordinances can be read in 2 different ways, one of which would allow the dock and one of which would not.
Your
We have-
ordinance,
just hold on a minute.
sure.
Yeah,
We have asked for an attorney to make an opinion, and we're told that there's no money for the attorney. So,
and we've had one attorney who tells us that the dock should not be built.
yeah,
yes.
but it didn't directly answer all the questions that were placed to that person either. So at that point, if it's not clear, and if we can't get an opinion from the town attorney, then what I'm doing is I'm looking at what other things should we consider in determining which way to go on this application.
Well, one thing is who has the burden? And the burden is not on us. The burden is the applicant to show why he complies with that, standard. And if it's 50-50, unfortunately, it doesn't go that way. I think that's the way it comes out. the ordinances clearly state who has the burden.
So are you suggesting?
Well, I would be more comfortable if the applicant had an attorney's opinion. If we can't get an attorney's opinion, he should come in with an attorney's opinion that says what he says, which is that the subdivision law, that the MMA doesn't know what they're talking about, and that,
I can do that. I mean, I'm reluctant to get an attorney involved. It seems a bit of an escalation, but if you're recommending it, I can certainly do it.
well, I'm just suggesting that that's a way to break the logjam, and it might then spur the town into making a determination what it's gonna do on this thing, because this isn't, High Head's not the only pre-existing.
So I think we could use it
subdivision.
not being the, only subdivision that this may be applicable to insist that the town make a definitive declaration that this is the way we're going to read this statute going forward, and this is how it applies. Because we're gonna be back when somebody else has a different subdivision, and they're gonna say, no, doesn't apply, because we have a community dock, we don't use it, and other people have, residential docks. So I think we have to have a definitive answer.
The other approach would be that the board is the one that determines how to interpret the Harpswell statutes, unless and until the appeals board says otherwise, or the court.
That's another option.
And, if we're wrong, then somebody's gonna tell us we're wrong. And as long as we're consistent in how we apply that, and then the unfortunate thing, and where the issue that the Board of Appeals can reach is this fairness, issue of the fact that other lots in this plan development clearly have been allowed to build docks. And I don't know whether they ever reached the planning board, or they haven't in the last 6, 7 years that I've been around here. There hasn't been a
Okay,
subdivision.
okay. I want to just take the temperature of the board here, and see where we go. I think that we have the option of denying the application based on these findings. And as Howard has clearly articulated, the applicant can go to the Board of Appeals, the applicant can hire his own attorney and come back with his own facts, which is totally appropriate, complete option. We could approve the application if we want to, or we could table the application and direct our interim staff. I'd be happy to meet with Christie, with Howard, or with Dan, and explain why we need to have money for the town attorney to take a look at this while it's tabled. Those, to me, are the three options. So I'd like to take the temperature from the board about.
How do you feel about that?
I feel that there's two big questions, whether High Head is a subdivision under the law or exempt because it's before 1970. I think that's clear, it's not. High Head is not a subdivision. The Harpswell ordinance is also very clear. It says the requirement that if you have access to a dock only applies to subdivisions that meet the state subdivision requirement. So to me, it is very clear right now, not so fuzzy. Now I don't understand, there's an argument being made that because we incorrectly changed the border under the subdivision law, but it seems a stretch to say that that somehow makes me a subdivision or all of High Head a subdivision.
I understand.
I don't think we're saying that, but that's okay. We're going around on that point.
Okay, so I'd really like to hear more from the board.
Why are you looking at me in particular?
I'm an associate.
Okay.
I'll speak up then. This one's a quagmire, is the only way to put it. I can't make a firm decision, because I don't know, I'm listening to the different legal opinions, and while I'm not attorney, I have been involved in law enough to know that what seems clear and fair is not necessarily what's legal. And that can be the problem too. I would really, and also going forward, like this resolved clearly, so future board members, future applicants don't get caught up in this mess. We need a very clear answer here on what the rights are of the applicant and the communities here. I would like to get an answer. So I think now the question, how to get that answer, it comes down to time. If you're willing to shell it for right now, while we try to get that information.
I could
That
speak
might
to
be
an
the
attorney
longer
to
one.
try and get a legal opinion. I didn't want to do that because I felt like it was, you know, attacking the board or something, but if you think
No,
that's
we're not
reasonable, I'll
looking
do
at
it.
attacking, it's just trying to get clarification.
Well, I think
Yeah.
the choice for us is to table this and seek to get the town's gonna, if you, the reason I was suggesting that you do it is because that's gonna trigger us to do it too. No question, then we'll have two opinions, and we can then make a clearer decision, but maybe that's not fair to ask him to spend money when it's our ordinance, so I would suggest that we table this and again ask Christie to get Amy Chow involved and see if she can give us some clarity on it. She may not be able to. This may be a case of first impression. Doesn't seem to be a lot of case law on this, and this is a unique provision that's not in everybody's subdivision acts. It's not in the state one, so.
Okay.
Well, then, I think that, you know, one of the things that Howard mentioned earlier makes an awful lot of sense, which is that it's the responsibility of the applicant to provide enough information for us to approve it. And since this is a legal issue, that's turned into a legal issue, if you were to provide that, then at that point, if we don't have a contrary legal opinion, it would seem to me that at that point, you've met your burden.
I'm not going to agree with you on that, because I think we've already heard from 3 other board members that they really think the town needs to answer this question.
But if the town doesn't, if the town is, we can't hold up an applicant forever because the town doesn't have the money or is not willing to do that.
Totally agree with you about that, but I think, as Howard has said, we can table this and go to Christie and say, we need to get some good information about this. And I would even suggest, because it's a legal issue and because staff really probably, Matt won't be here, but I would guess it would be putting an undue burden on Margaret to have her try to explain in language that, you know, our town, Christie could communicate to the town attorney, that we should do an executive session and actually have this legal issue discussed with Christie, and maybe even get Amy on the phone.
We should do that ultimately. Maybe the way to approach it.
Yeah.
Maybe the way to approach it would be to go back to Christie and to say, listen, we're in a position right now where we really don't know what to do. Either we get a lawyer's opinion, our lawyer's opinion, or the applicant is going to provide a lawyer's opinion, and depending on how we receive that, we may act on that as being the best authority that we have. And so that becomes a two-step. She either says, yeah, we will find money for it, and if she says, no, there's not money for it, well then, we ask you to provide a legal opinion for us.
Okay.
Which is, it's not a perfect answer by any means, but,
Just trying to figure a way out of this.
but you know, I can't, in good conscience, hold you in limbo because we can't get a legal opinion.
I think that's completely correct. It's not fair.
I agree. I think whoever can come up with a legal opinion first, if he can get a lawyer and have his lawyer say that it trumps it before the town's willing to put up the money, then he's met his burden of proof.
Okay, I will make a motion if we're ready to table this application in light of the conflicting information from our two board members who are attorneys and the relatively incomplete information from MMA.
Confusing, the confusing
Confusing
information.
information from MMA, and that the chair will contact the town administrator to communicate our concern and request that the town attorney, money be found to get the town attorney's opinion on this at the earliest possible date.
Yeah, I was going to ask whether we were going to try to give a date at all.
Yes.
And if she says no, to
Well, then we'll-
communicate that.
Then we'll come back to us and we'll
Well,
make a
then we'll
decision.
but then we communicate that to the applicant, so we can have something to come back to the next meeting,
Okay,
Yeah.
right?
okay, so,
I think we should put the date a week before the next meeting for them to contact our lawyer, so that at least gives him, or we should set a date in stone, so we give him time,
totally agree,
you know.
totally agree.
Because without a date, it'll just kind of hang out there in
Right.
limbo.
Okay, so a
Yeah.
week before the next meeting, does that sound?
That
I'm
enough
traveling
time?
next month. This will be the third month in a row, so that's,
Sorry, we don't mean to keep you on the hook like that. We're just trying
Why don't we
to
table
figure
it?
out what
I
the right
understand.
thing is to do, and I know this probably will come up again,
Yeah.
and we don't like to leave people in limbo.
Would it be helpful for you if we tabled it until the February meeting?
yes.
Okay,
Okay.
let's table it until the February meeting. And I will get in touch with Christie at the earliest convenience, and we will be in communication with you about where we are.
Okay, thank you.
Thank you,
Yeah.
thank you.
Right.
So, I make a motion that my motion stands. I guess.
Okay.
Read back the motion. I move that we table this application, that I go to Christie on the board's behalf, requesting that she contact the town attorney to get a more firm opinion on this issue, and that we take this up again based on the town attorney's opinion or not at our February meeting.
I'll support that
You
motion.
second that motion? Okay, any discussion, further discussion?
No.
All right, all those in favor? Thank you. All right,
All right.
wow. All right, thank you.
We'll get there.
Margaret's going.
Yeah,
Oh,
Yeah, Thank you.
Ball's
Okay,
in her lap now.
all right.
I'm just getting a cup of water.
Wow,
Wow.
that.
Okay.
Does anybody
Still
need
awake?
to take a break? Anybody
There.
need a break?
Let's keep rolling.
You gotta
Okay.
say something else.
All right. Our next application is, let me get this in my packet so that Margaret knows where we are. The next application is 230201, Andrew Donnelly, map 40, lot 48, 512 Mountain Road. Site plan review. This is consideration of an application for a multi-use commercial project. This application has been before us for just about a year, I think, if not more, but here we go. Mr. Donnelly's been patient with us, and we have been patient also, trying to work with him. 0 Harpswell Island Road is a 1.89 acre lot, not quite 2 acres, located on the corner of Mountain Road and Route 24. The applicant is proposing to convert the previously approved temporary seasonal use of the property to a permanent one. To facilitate year-round use of the property, the applicant proposes the construction of a country store and a mixed-use maker space, which is in quotes, with an attached dwelling unit. The property is located in the Interior District. Commercial and residential uses are allowed in this district with planning board approval. And the application is subject to the standards of Section 15 of the Site Plan Review Ordinance. I will ask the town planner to update us here on where we stand with this so far.
Yes, so this application was, like the last two, tabled from a previous meeting. There was a few things that were missing from the application at the time. I communicated those to both the applicant and the engineer, and we have gotten those materials back, have gotten updated site plans, and have also gotten a few responses on some other lingering questions that have come up. I have here, I don't know if this was included in your packets, but this is the email from Jerry Mitchell, the septic designer, just confirming my draft motion that states that while residential uses are not listed on the septic design, that it is sufficient for what has been proposed in terms of the gallons per day and design flow. Another question was asked about the presence of a vernal pool and what impact that might have. This question seems to be out of our jurisdiction in a way. We don't specifically in Harpswell regulate vernal pools unless they're of a certain significance. Otherwise, they fall to NERPA or DEP. There is listed a 250-foot, I believe on the plan it says setback, but really that's more of a, almost an administrative area for the DEP. So anything within that 250-foot radius might need to go to the DEP for additional permitting. One of our standard motions in these is to ensure that any state and federal approvals are received from the appropriate officials. So if there is a DEP permit or NERPA permit required for this project, that could be done as part of a condition and not in time for a regularly scheduled meeting or in time for approval here.
He wouldn't be able to start the project.
No, he
Without
wouldn't,
that.
he wouldn't be able to start the project without without those permits and approvals. But we can still approve it here at the municipal level. Otherwise, we have copies of this email from Jerry Mitchell if anybody would like one.
Okay, thank you. Thank you. Does the applicant have anything they'd like to say to the board? Attorney.
You guys are a teacher.
Would you come to the podium? Thank you.
I learned from you guys, and it morphed over the year that it's been, on the board, so to speak. I think it's evolved to something that looks great with your help and Joe's help. Joe actually took my design and took it one step further, which blew me away. I didn't know that could be done. And when that happens, that makes me happy. I think what I have is going to work well for the town. And right from the get-go, right from the very beginning, my approach has been to work with the environment and be, very considerate of the permaculture just there. And to me, it's like an organic fabric of roots that's just like nothing I've ever seen anywhere else in the world. And that's the way Harpswell is. And so, I think that what we have is a great solution for that little spot. I'm even when Howard was talking about the drive-through, I really listened and watched that video multiple times. I went round and round and round. And I learned that you can't have a round drive-through. It has to be a pill shape to work, and I could have pushed everything back in the woods, but I wasn't going to go and do all that. Too complicated. Got to keep it a little more simple. And those are one of the lessons that I've learned, and I appreciate all that stuff, and I'm happy with where it is right now.
Okay, thank you. Does the board have any questions?
I don't think that we were stopped at the preliminary question before,
Okay.
which is finding whether the application met all of the submission requirements. And I think we should probably
Well, we certainly can do that. yeah.
find that first and discuss the proposal.
Well, I wanted to just ask if the board had any questions with regard to completeness or anything, but we certainly can do that. Do you want to make a motion?
Yeah, I move that the planning board finds that the application of Andrew Donnelly meets the submission requirements and is therefore in order for consideration by the board.
Anybody want to second that?
I will second that.
Okay, Howard seconded it. All in favor? Okay,
Okay.
all right. Any questions regarding the application by the board? Questions, thoughts, considerations?
I read through, I think I've read this quite a few times. And I read it again, and I hadn't remembered that on page 20, where it's country store, makerspace, et cetera, it says a proposed multifamily housing development?
There's two buildings, and it's basically the parameters are what the driveway permit is from the state. They gave 2,000 square foot, okay, so that was put into two buildings. And so one of them would be like where live-work space like you might see in, if you've ever been in a city and, you know, you're an artist and you live and you
Studio.
work in the same space, same kind of a scenario. That particular building, that studio makerspace building. Backside would be where a maker might live, like perhaps me. I don't think that would be my forever spot, but maybe I'm there for a little while to get it going. And then the front of the store is the goods you make and what you sell on the front. So, and then somewhere in between is where you make things.
Maybe it was just the terminology I had.
Yeah, I mean,
Where
like
did you see
T-shirts.
that, Courtney?
Yeah,
Very last page.
It's on the traffic
Right,
analysis.
page
It's under the
20.
traffic
It says right
analysis.
here,
I just thought that was
proposed
a mistake.
Yeah,
Oh, I don't know.
That was probably, that was.
I saw it, and so.
No, that was a typo. I apologize for that.
Oh, okay.
I know the project that we pulled this from, and it was a multifamily housing project, so I just missed
Oh,
that.
okay. Well, I was, I noticed that, so I will remove that. Thank you.
I still don't.
Don't worry, Joe, I'm familiar with
It's on the
mistakes like
first
that. Happens here all the time.
Okay, thank you. That was, I was trying
So
to,
we can just strike that?
Okay.
I do have on the drawings, just a couple clarifications, just because it could be, again, maybe just a typo. But on drawing C3, it shows the building square footage. One was 965 square foot, and the other's 1,026. But on the grading and drainage plan, which is C4, it gave the square footage, the ground floor square footage of 98 square feet and 97 square feet. So wasn't sure, because that would make it like a really tiny building,
Yep.
So I just wanted some clarification.
So on the grading plan, the thing that's listed, and I see there's another typo there. I'm 2 for 2 today. It should be FFE, which is finished floor elevation, and that means like when you set the elevation for the first floor of the building, that's where the level is. So it's either gonna be, you know, the grades in the vicinity, like of the northernmost building ranges from 97 up to 100-ish. So the finished floor of that is gonna be 97, and it's gonna kind of step up the grade.
Gotcha, okay. I
So
was
it's-
wondering, I
that's
was
not the
getting a
square
little
footage.
puzzled
Yep.
on it, that's all. So thank you for the
That's
clarification.
the elevation off of sea level, right?
Yeah.
Yeah. Okay, so.
And the
We're up,
buildings are,
we're up a big hill from the water.
Just a-
100 feet.
the design of the project is to be perched on top of the ridge
Mhm.
for the plumbing, so that
On top.
everything's natural, there's not a whole lot of pumps and extra mechanical wildness going on. You know, gravity flow into the septic right behind, in the center of the lot there.
Now, how many, because I know as a workshop and living area, you're talking maybe one bedroom, two?
It's, yeah, the rule, per Jerry's, Mitchell's, septic list, it says 2 bedrooms, or 2 or less. So, yeah, I don't know, I think 2 would be pretty cramped, but that's what it says.
But he's given the flow for
Right.
two.
flow.
I really appreciate the plans and the elevations and the work that you've done, because this has changed quite a bit. You know, I think you have a really creative imagination, and we've gotten a lot of concepts and ideas from you, but nothing that we could really quite pin down. And that was part of why, you know, it's taken us a while to get here. So it's good for us to actually have something, because we need to know what we're dealing with, so that when we go out and Codes does its work certifying things, that it actually has something solid that it can work with. And you'll need to stick to the plans that get approved. So just make sure that we're clear on that. And I just want to also say, I noticed that you did put for your makers, or your, you know, your seasonal business, that you had signs up around town advertising those, which are not really legal, because the town sign ordinance doesn't allow that kind of thing, but you did take them down. You didn't leave them up, you took them down at the end of the weekend, so that's very much appreciated.
I think that may have been the applicant for that, I didn't, but, yeah.
But you were, one of the things we said when we gave you that approval was that you were responsible for all the permitting for those businesses on your property.
And they did that permit, but I don't even know what signs you're referring to.
Yeah, they were signs advertising, you know,
Food truck?
gourmet stuff in the food truck. Yeah, they were on my corner and several other corners. So, but you did take them down, so that's much,
Or
or
she
someone took,
did.
someone took them.
I didn't even know that they put the signs up.
Well, it's really appreciated that
You know,
he's responsible.
like the sign of political signs.
Yeah,
Yeah.
Yeah,
like
like
that.
a certain
And-
time you can.
yeah, yeah, I like those. And the town has a sign ordinance, and sometimes it's, you know, like a small town, we try to help each other out. So
Yeah,
I just wanted to make a note of that. I don't want to pin you down on that in any way. Actually want to thank you for having whoever took them down, for taking them down.
yeah, and if that comes back around to doing a food truck somewhere, I'll make sure they know.
Okay, all right.
I have one more
You
question.
mentioned the sign.
Pardon me?
You mentioned the sign. We're not approving a sign, are we, in this?
There is a sign,
I know
In
there's a
this-
picture of
Yep.
a potential sign, but that's,
I believe Codes will also,
Codes
Take a
deals
look
with
at
that.
Codes,
yeah,
yeah,
yeah.
Joseph, the size.
I don't think we, who takes care of the sign ordinance? Do we do that? Is this part of our responsibility? Because
I believe that's Codes' responsibility to do. But there is a standard for signage,
Yeah,
so you have to cover that
yeah,
aspect of
we
it,
can,
but
Yeah.
not the enforcement action of it.
no, but we can ask for design standards and things like that, so we are responsible. I did notice with regards to signs that you said it would be a wooden sign, and the sign in the picture doesn't really quite match that. I hope the sign in the picture isn't what you're thinking of, because that's not really in keeping with
This drawing, the perspective drawing?
the sign in the.
Plus, it's a pylon.
It's kind of an overlay, and it has
Yeah,
business
this-
store, maker's space.
Oh, yeah, that's like a wooden panel, you know, so you can see the sign from this way and then from that way,
Okay.
on a triangular, single pedestal. The
Okay.
design is supposed to kind of match all the other signs that are state put up signs like for, you know, destinations. So I'm trying to
Okay.
make it harmonic with those other signs. So it has that feel. And then it'll be lit. It's not gonna be, there's not gonna be any kind of like a fluorescent. It's not that kind of a fluorescent sign. It'll be,
Well, although,
you know, a projected light onto that wooden panel
This
sign.
is a site plan.
Okay.
review. We're not approving the sign.
No, but we do have,
We have a picture of.
we have a
of
picture of it,
proposed sign.
and
Yeah, but he's gonna have to comply with the
Yeah.
ordinances when he
Absolutely.
goes.
So whatever the
Absolutely.
Oh,
sign
it's just a
ordinance is.
placeholder.
Yeah, and the applicant understands there's a separate sign permit package. We just wanted to show you something that,
Okay.
example of what's.
As long as we're not
Yep.
gonna get held to
yeah,
that particular sign that's
Yeah,
shown
that's-
in,
yeah, I want to make that
Weeds.
clear, that we're not approving this as part of the package. Okay, all right,
I've got one more question.
sure.
Maybe Ryan, you can help. So on the subsurface wastewater, it shows 4 different buildings. But in all the other drawings, it's showing 2. So was kind of curious, how those were future possibilities, just,
I think that was done, part of his initial design, when that's scaled down, that's why we went back to the septic designer to say, all right, with this new scaled down design, does your design that you're looking at there still work for this use?
He
That's
gave
what
us
said.
because it is a 1/1/23 date, so that's why I wasn't sure how that played in.
Yeah, so the septic design you have still works, but the site plan is outdated.
Gotcha,
on
that's
that.
fine.
Yep.
This isn't in our current, is this in our current packet?
Yeah,
Yeah,
Where?
The septic.
he added the back page to this, which sort of
Ah, that
updates
looks familiar.
the septic
Yeah.
usage.
There's possible
Yeah,
locations
yeah,
for
I see
buildings.
that, yeah, I do remember seeing.
And he didn't change the first 3 pages.
And then I handed off the page that, just today, out of the press, we got Jerry's,
If you'd like to pass
thumbs
this
up for
around.
just exactly
Here
what
we
you're
are.
talking about.
Yeah.
If Matt wants to pass those down, so you can have that, it's a replacement for page 14.
oh, okay, super.
He's got that, it's around, I dropped off 10 pages there.
It's a replacement.
This one's still loose, so great.
And it shows,
Because this one is dated, almost a year old.
Yeah, I would say it's
Yeah.
it's an update, not necessarily a
I'm
replacement.
Then he
manspreading.
added a page.
All right. Does the board have any more questions of the applicant at this time? 'Cause otherwise, I will ask if there's anyone from the public that wants to say anything.
I just have a quick question. I know this is ultimately, you see this as a phased project. I want to make certain that you understand that it is likely that if you cross the 99 trip count, you are going to be responsible for making substantial improvements to the traffic flow there in that corner as part of any further development or other phases of this commercial project.
my understanding is that there would have to be a traffic study. That's
Right.
what they suggested, or
Right.
said if you want to, if it's more than that 99 trips, and you want to do something more than that 2,000 square foot that they allotted me, then a traffic study would happen,
Right,
need to happen.
and if that traffic study showed that you would need, for example, turn lanes and the like, that would fall on you, not the town or the state, in all likelihood.
You think? Is that-
Yes, I do. If this is a very successful project. My thoughts on this are that this is a pretty good commercial site. We don't have too many commercial sites left in Harpswell, but that if it became a lot of traffic, it's close to that intersection, and the turning, especially cars that are coming around from Brunswick, that then gonna turn in, and the cars that are exiting, this is gonna be an interesting traffic problem, that somebody in the state's gonna put a burden on somebody to fix, if it's really successful. This is a good commercial site, and I think we should think about that through. It, at this level of construction, doesn't appear to me to be a problem here at this point. But if we were getting into a larger development at some point, then I think that's something that would have to be really considered. Turn lanes, widening of that intersection. type of a thing. And, you know, there was discussion of an entrance onto 24 as opposed to Mountain Road to take it away from that intersection. I think all that's gonna come into play as if this develops into something bigger, and something that we would be thinking about as well. So I just, fair warned is the way I would
It'll
approach
be
it.
well crafted by the time we come back with it.
You were going to have a drive-through at one point, correct?
Yeah,
But-
there was gonna
But
be
no
like
longer, right?
Yeah, that's
Okay.
been eliminated. And
Because I
those are-
see you
those
have to
type of
have a
uses
traffic
are-
study if you have a drive-through.
Yeah, those are extreme traffic drivers, so, you know, the uses he has right now, I think it's around 50 trips he's asked, he's about halfway what he's allowed from DOT. And, you know, I've talked with Andrew a little bit about the future of what he wants to do, and it's kind of dependent on, you know, how things change in the future, but none of the uses I would think are gonna trip him over that 100. Of course, things change and, you know, in terms of what's he want to put out there, but you're right, if there's anything that arises from that increase over 100 trips or 99 trips, and there's improvements that need to be made off-site or on-site, then it would be your responsibility. But again, that's if you're doing future development out there. So,
I just want to
Yep.
make sure everybody understood the ground rules.
yep.
Thank you.
Yeah.
We want you to be successful, just not too successful.
All right, I'm going to go back to inviting anyone from the public, unless there are other questions that would like to speak. No? Okay. All right, thank you.
You ready for a motion?
Well, don't we have to read the findings first?
Well, we make the motion, put it on the floor, and then people can ask any questions they have about the findings.
Okay. Why don't you go ahead and do that?
I move that the planning board incorporates by reference the findings with respect to the application of Andrew Donnelly proposed by the town planner in sections 15.1 through 15.21 of the site plan review ordinance for the use of the property as a year-round retail site.
I can't find your findings.
I'll second you.
Now we can talk about any sections that we want to talk about.
Okay. Any discussion?
They should be in your
Seconded?
packet, but there are some up there.
All right, moved and seconded. All in favor?
Someone want to second this?
She's already seconded.
Oh, I did, okay.
Sorry, I was asking Matt something.
She's
so I-
asking if, does everybody have the draft motions and findings?
Yes.
I
Yes.
have the draft motions dated December 13th, 2024.
Yes.
Are those the up-to-date ones? Okay.
That's
good.
what we're incorporating. by
That's what we're incorporating by reference.
Do you want me
in
to
the
grab you a
motion.
copy?
I can go get my own copy, thank you. Yeah.
Actually, Matt, I don't think I have those.
You shouldn't have to do
Are they up there?
Yes, there, yeah. There should be some copies left.
all the lines and everything.
It's getting lost. I was like, what's going on? That's why.
No, I was not alone.
There we go. That looks better.
Great.
But these are the ones that Margaret sent out, is that right?
Yes,
Okay.
It's odd that I don't have.
I would like to just, summarize the findings, is that what we're gonna do?
That was kind of what I
We
was going to
did.
do.
Yeah,
but-
go ahead. I have one finding that I would like to muck Mickey Mouse around.
Okay, all right, let me go through the findings of fact.
Thank you.
Just really quickly. Okay, we haven't taken a vote yet.
No.
No.
No, we just put it on.
We
the
just
floor.
put it out.
Okay.
No, I
It's
asked
on
the
the table.
question because I
Okay,
had
you've
to
all
pick
got
up
what
the
you need?
findings, yeah.
Yep.
All right, so, I guess I move that the planning board makes the following findings with respect to the application of Andrew Donnelly for, you did that.
I did that, yeah.
So let's go through the dimensional requirements. 15.1. There's a finding that The lot's located in the interior district. It meets the minimum lot size frontage requirements. And 0.32 acres will be developed, including approximately a quarter of an acre of new impervious surface. Anybody have any comments about that or questions? All right. 15.2, utilization of the site. Finding is that the proposed development will reflect the natural capabilities of the site and incorporate natural features. Finding of 15.3, adequacy of the road system. The finding is for 15.3.1.1 and 15.3.2 that access to the site will be from Mountain Road, a public road with adequate capacity. The main DOT driveway permit limits the use to less than 100 peak hour one-way trips, and the proposed use will not generate the level of traffic triggering the additional requirements. 15.4, access to the site. Finding is that the proposed driveway is located on Mountain Road. The applicant has supplied a traffic analysis stating that the use will generate less than 100 trips a day. The access egress way onto Mountain Road does not exceed 30 feet.
What does that mean?
Finding 15.5, access and egress. The finding is that the driveway is located more than 50 feet from an unsignaled intersection. 15.6, internal vehicular circulation. The finding is the proposed layout of the structures provide for adequate internal circulation. Roadways will be appropriately marked, and parking spaces are well-sized and spaced. 15.7, parking. The finding is that the plan provides an adequate amount of parking spaces for the proposed use. 15.7.2, layout and design. Finding is that the plan provides for adequately sized parking stalls. 15.8, pedestrian circulation. The finding is that a pedestrian walkway will be created between the structures and the parking area to allow safe movement across the site. 15.9, stormwater management. Finding, there are no proposed stormwater improvements, and limited impact will result from the development. Just noting that,
I'm sorry, on this one, I thought you had put in the application at one point that the water was gonna be diverted to a particular, to basically beds.
That was when I was the engineer.
So that's not in the cards anymore.
There is a small portion of most of the existing gravel that's there now. Will that drain to this crushed stone area that's around where the existing well is? It's a fairly small portion of the entire parking lot. The majority of it's gonna flow off-site, and based on the analysis we did, I mean, one thing you guys all know, all this soil is here is just a little bit of soil on top of ledge, so these are all de-soil, so it's pretty much the change from the wooded area to the impervious area didn't result in a significant increase in the flow. But there is a small little area that will allow some infiltration into the
Okay.
soils.
Thank you.
Yep.
I have a question. Doesn't the ordinance require that stormwater be handled on-site?
I mean, ultimately, the stormwater flows off-site.
Right, but that it doesn't drain directly off-site onto someone else's property, or, I mean, and the original proposal was, as Howard said, that it would all be handled on-site.
The stormwater, I mean, it's gonna flow off into the wooded area and eventually get to off-site area. Mainly, it'll mostly get to the roadway, and then it flows along the road. There's some existing drainage structures along there that'll flow into.
Okay.
But the analysis we've done is that there's no increase in the peak rate flowing off-site.
Okay, okay.
Yeah, so the way I had approached this was, that to the extent possible, this is 15.9.1, to the extent possible, the plan must retain stormwater on the site using the natural features of the site. I thought in this case, given that the stormwater analysis indicates that there is very little change in the flow pre and post development, that maintaining that natural flow would be sufficient to meet these standards.
Okay.
If you have another interpretation, we can certainly edit this, though.
No, I see what you're saying. My only concern is the vernal pool. Because the vernal pool is actually downslope of one of the buildings. And I realize that's not our purview, but, you know,
If I remember correctly, I just want to look at this to confirm my.
yeah, I'm just,
So the vernal pool is located in its little own pocket.
yep,
We went out there and we did some on-the-field surveying. We also supplemented that with some LiDAR aerial topography, but everything we could see is this, it kind of goes from where that building is located, goes up and then back down. So the vernal pool is kind of surrounded with this little bowl that drains
Yeah.
into it, and none of what we're developing is within that bowl. So the bowl is going to remain untouched.
yeah.
It doesn't say that it all has to stay on there, though.
Yeah,
Just to be clear, if you
To
look
the
at
degree-
5.9, to the extent possible, it should be retained. And
Yeah.
then the next one says, stormwater runoff systems must detain or retain water to minimize the rate of flow from the site after development.
yep,
But it still anticipates that there's gonna be a natural flow.
So,
Okay.
so none of the stormwater coming off the property will get to the vernal pool.
okay, because I'm just looking at the elevation and where the edge of the building is, I don't have it's the building,
The northernmost building.
yeah, the westernmost building. It's 96.39, and then the vernal pool is 95, so it's draining down toward
Yeah, it's
the
got
vernal
footage
pool.
of elevation.
Anyway, that's not our purview, but I did want to just bring that up.
Yep.
Okay, erosion control, 15.10. The finding is that the applicant anticipates limited erosion due to the large presence of bedrock on the site. Limited excavation is proposed. Sediment barriers will be employed where needed. Okay. And who determines that, where needed? Who's going to be the construction?
I believe there's part of,
Oversee
part of the plan set is an erosion control plan. So we've located sediment barriers down gradient of any disturbed areas. I'll also note that one of the conditions is that he has to comply with the best management practices for soil erosion. I mean, of who requires it, ultimately it requires, if he just went out there, put no controls down, it would be ultimately to either a resident or code enforcement to notice it and, you know,
So the project manager is going to be the applicant here?
yeah.
Okay. Thank you. 15.11, water supply and groundwater protection. The finding is that there's an existing well on the lot. 15.12, subsurface waste disposal. The finding is that the applicant proposes a 370-gallon per day septic system, and the septic design does not seem to directly account for a dwelling unit on the property. However, we have
That's not right.
we have corrected that. That has been updated in the findings.
So why don't we just take the word not out?
That is a good
Does
idea.
account,
It-
does account.
It does seem to directly account for a dwelling unit on the property. Thank you. 15.13, utilities and essential services. The finding is utilities shall connect to the structures and will not cross scenic views. 15.14, natural features and buffering. The finding is that the proposed development will utilize and incorporate natural features in its design. Additional buffering is not proposed. 15.15, lighting. The finding is that lighting will be shielded and will provide for safe travel across the site. 15.16, water quality protection. The finding is that the application does not propose the handling or storage of potentially hazardous materials. 15.17, hazardous, special, and radioactive materials. The finding is the application does not propose the handling or storage of potentially hazardous materials. 15.18, solid, special, and hazardous waste disposal. The finding is the application does not propose the disposal of potentially hazardous materials. 15.19, historic and archaeological resources. The finding is the proposed activity does not appear to be located on a site with identified historic or archaeological significance. 15.20, floodplain management. The finding is the portion of the site that will be used is not within a special flood hazard area. 15.21, technical and financial capacity. The finding is that the applicant has demonstrated the ability to continue to develop the site for commercial use. Based on these findings,
We have to vote on that.
okay,
I would like to just modify that last one.
yep,
I would like to strike for commercial use and add in the manner set forth in the application.
okay,
Would you repeat that,
Yep.
please?
I would like to strike the words "for commercial use"
Yep.
and replace it with "in the manner set forth in the application."
Okay.
okay. We have read the findings, and we have two amendments to the findings. One is to take the word "not" out of, where is it?
The septic one.
Out of the finding for subsurface waste disposal. And the last is to,
Technical and financial.
technical, the commercial use, as noted by Howard. So we have, do I have a motion to accept these findings as amended? Yes.
So moved.
Do we have a second? Howard seconds. Any discussion? All in favor? Thank you.
I'd like to ask about the vernal pool.
Well, I'd
Is
like
that
to
okay?
put that into our conditions.
About, I was wondering when you said it's not in our purview, but it does seem, I mean, if, for example, if it's determined that it's a significant vernal pool, I read about those, then there are certain things that are supposed to be done, and I know Mr. Donnelly, who's very environmentally conscious, would want to do whatever it was, but I wondered who oversees that?
DEP.
No, is he then required to consult with the DEP? Do we say something to the DEP? Who oversees that? What I'm saying.
I was gonna, our standard conditions say that before you can start on the project, he needs all the state and federal permits. I would just like to add, including without limitation, any DEP permit due to the fact that there may be a vernal pool on the site.
Right, and also there are some wetlands as well, some little pockets of wetlands I saw. So,
Would you run that by me again? Because I'm going to put that under 4, including,
Without limitation, obtaining a permit from the DEP due to the fact that there may be a vernal pool on the site.
a significant vernal pool.
Well, why don't we just call it a vernal pool?
Okay.
They make
They'll
the,
determine how
They'll
significant.
determine, the state will
that.
determine,
Okay.
yeah.
and that's beyond our, and I think that's all we can do.
Okay.
Is that say you can't, you're not gonna get a permit until that's determined. And from what I looked at the emails back and forth that Margaret was able to obtain, they can't do that until the spring,
right,
when it gets wet.
Yeah, so for now, what they do is if you find a vernal pool, or what they call potential significant vernal pool, you treat it as a
As
significant
a,
vernal pool.
as,
So that's what, so assuming we get the approval
so you
tonight,
can file the.
I will submit the application hopefully tomorrow. And that will start that 14-day review process for them.
Right.
And then I don't think we're required to submit when we get the permit by rule approval, I don't think we're required to submit to the town, but I guess we are, because we're required to prove that we got those permits, so.
Right.
But I'll also copy you on
That's fine.
I'll copy you on the application I sent out as well, so you're just aware that it's,
And copy Margaret.
okay,
on
Margaret
that.
as well.
And as far as Courtney's question about wetlands,
Yeah,
there's a threshold amount of wetlands before the DEP takes jurisdiction.
The first
So-
1/10 of an acre, they don't.
yeah, and I couldn't tell by looking at it,
Yeah.
like how big they were. I just saw there were several little pockets of wetlands. I was wondering about them. Can't fill them in, I know that.
I will express some confusion. If we can't determine whether it's a significant vernal pool until spring, but you're starting a 14-day approval process, how does that relate?
So we assume everything that it's significant. So if he goes back in the spring, which I recommended to him, I don't know if he'll ultimately go forward with it, but if you can do a vernal pool delineation in the spring and determine it's not significant, you file that with the state, and then it's not significant forever. And if he does the delineation, if he's fine, it's significant, then he has to, like he's always been doing, treat it like a significant vernal pool. So it's his benefit to determine in the spring if it's significant or not, because if it's not, it eliminates a lot of the limitations of the property. Because right now, he's limited to clearing 25% of the 250-foot habitat on his property, the portion of that's on his property. And right now, he's at like 24.1%. So he's kind of maxed out of what he can clear within that area at this time. You can get an individual permit, they call, to get more clearing than that, but you have to have a pretty good reason for getting that. And just that you want to clear more is not really, a good reason to have.
What about setback requirements?
There's the only thing you can't impact is the actual vernal pool itself. So if you wanted to clear trees right up to 2 feet from the vernal pool, you could do that as long as within that 25% area. And something that's a little also funky about vernal pools is this vernal pool is actually half located on his property and half located on his butter's property. But let's say it was entirely located on his property. The setback doesn't apply at all to the abutter's property because the vernal pool itself isn't located on there. So there's some weird regulations with
Yeah,
vernal pools.
On the main.
Okay, I found that a little confusing.
Yeah.
Okay, since it's not our purview, I won't go into it, but,
Yep.
so, all right. So we have findings, we have voted on the findings. So based on the findings as amended, part of this application, I move that the planning board approves the application of Andrew Donnelly for the development of a country store and makerspace with attached dwelling unit on lot 48 on tax map 40, subject to the following conditions of approval. Number one, this approval is not final until such time as final plans showing all conditions of approval and any waivers granted have been signed by the chair of the planning board. Number two, this approval is based on the approved plans and on all submissions and information provided by the applicant at final approval, whether referenced in any findings or conditions of approval. Item three, this approval is dependent upon and limited to the proposal and plans contained in the application and supporting documents submitted and affirmed to by the applicant. Any variation from the plan, proposals, and supporting documents except de minimis changes as determined by the town planner that do not affect approval standards is subject to the review and approval of the planning board prior to implementation. 4, the applicant shall obtain all necessary state and federal approvals before the applicant commences any land activity pursuant to this site plan approval and shall comply with the requirements of those permits and approvals, including, without limitation, attaining a permit from the DEP due to the fact that there may be a vernal pool on site. Could probably have reworded that better, but I think that's all right. Item, or number 5, all work shall be completed in accordance with best management practices for soil erosion and sedimentation control. Motion has been made. Is there anyone that would like to second the motion? Howard? All right, motion has been made and seconded. Any further discussion? All right, all those in favor? Thank you. Go forth and make makers.
Thank
We
you.
did it.
Very good.
Thank you for, thank you. Thank you, Sightlines. Really,
Yeah, good job.
nice job.
Next one.
Okay, wow, that's a lot of paper.
Yes, it is.
I had one sheet.
Well,
No, I was not on the
saved these for my
sidewalk.
granddaughters.
I definitely
The
thought
color
that
on?
everybody's.
Yeah, they like
Yeah.
the color on them.
That's a good idea.
Yeah,
I just give that to my nephews now.
yeah.
You guys.
All right, anybody need to take a break?
We only have the new,
In-
we only have the plastic thing left.
I know, we do, but sometimes,
Let's
some
go
people need to
for it.
pee. I mean, if you need to,
Do you need to
if you,
pee?
no, but some people do. If you do, if you do,
Yeah.
Those Velcro on my
okay,
shirt.
there you go.
Beginning of it.
All right, we have one more item, and I'm gonna ask that the conversation be taken to a place where we can,
Keep
where
moving.
you guys can talk freely and we can finish up. This last application is 241201. It's a new business. Jerry and Ruth Welch, owners, Drilling and Blasting Rock Specialists is the applicant. Map 39, Lot 13, 23, the Tote Road. This is a consideration of an application to blast more than 300 cubic yards. I believe this application was, no. I have the wrong,
I have the motions if you need them.
no, I've got it, sorry. Took it out of the wrong packet.
That's my problem every time. No matter how careful.
All right, Drilling and Blasting Rock Specialist. Jerry and Ruth Welch own Lot 39 on tax map 13. The parcel is located on both sides of the Tote Road, containing 6.8 acres of area with approximately 500 feet of water frontage on Gunpoint Cove. The property is improved with a garage and a dock. The applicants proposed blasting for the foundation of a residential structure, and the planning board did make a site plan or a site visit to this, this location. The town has a blasting ordinance that regulates blasting in Harpswell. The ordinance establishes standards for blasting and requires that a permit be obtained prior to any blasting activity. The applicant approximated the recontouring of the site will require blasting 2,000 cubic yards, and Section 3.1B of the blasting ordinance requires blasting and removal of more than 300 cubic yards to be reviewed and approved by the planning board before permitting by the codes office, so the application is being reviewed. Does the planner have any additional information that he would like to share with the board?
Yes, we did receive an email after requesting a bit more information, trying to get an exact, or closer to exact number on how much might be blasted. We did receive an email from Joyce that said that it looks like it's going to be closer to 1,500 cubic yards with 30 blasts. I think the application calls for 20.
Yep. It did.
A bit more, but the application just didn't specify how much over 300 cubic yards were going to be blasted.
Okay, so 30 blasts and 1,500 cubic yards. Okay. All right, thank you, Matt. Does the applicant want to address the board? Please just state your name and,
Tim Carrington with Drilling and Blasting Specialist.
thank you.
the estimated yards is kind of, you don't really know until you actually get out there and shoot some grades and stuff, so, you know, that could vary some. But it definitely went, it's not over 2,000 for sure.
Right,
I'd say it's somewhere around 1,000 to 1,500.
okay, thank you. Does the board have any questions of the applicant's representative? Howard?
Where is the materials that you are blasting going?
I believe they take them off-site, taking the ledge off-site. We do the blasting, and then, like,
You're not involved in that
no,
aspect?
that's Turtle Rock hired us through the owners. And, so we don't do the excavation part of it.
Okay.
Is that a question that codes can respond to from the plans?
No.
But
No.
looking at the site,
No.
looking at the site and talking to the contractor, I believe most of it's gotta be taken off-site.
Right, but the contractor's not here tonight.
No.
No. That is not what we heard when we did our site walk.
Oh, really?
Yeah, we heard that it was going to be deposited actually on the site.
Yep, maybe I'm wrong, I could be
A lot
wrong.
of stuff.
Okay,
Like I say, I don't do the digging, so.
okay. Is there anyone representing the applicant who can answer questions about where the material will be moved on their property? No, okay, all right, thank you, sir.
I had one question
Oh.
for him. I know that we allow, Harpswell allows blasting between 8 AM and 7 PM. Do I assume, however, that you're not going to be blasting after dark?
Yes.
Okay, I
It's
mean,
more like probably 8 to 3, 8
well,
to 4.
I was wondering, it
Right.
says officially 7 PM. I just
Yeah.
wondered whether,
You know, maybe in summertime or something, if
Yeah,
or if you had
yeah.
a misfire or something, it might carry you over into, you know, a lengthier time. but-
I didn't know when you were, whether you would blast in the winter as well. I was just curious
Yeah.
about that.
Yep,
Thank you.
doesn't affect us.
So, just one more question. Does codes have the proposed dates and hours of blasting? He's just given us the hours, 8 to 3-ish.
Or you mean like, when is this gonna start?
Yeah.
Which-
I mean, I think the public should see that in the application. So that those people that are concerned about this in the neighborhood at least can know when the blast is gonna happen. And because if they then start to hear the horn and, you know, they may get concerned.
When
They're not
Joyce
aware
does,
of this.
when Joyce does her pre-blast, she gives them an on or after date usually.
On or after date. I'm just,
Yeah, good
it's
point.
in our ordinance that you're supposed to provide the hours and dates of blasting.
I know when Safe Harbor blasted for their building, because I was in the radius, the company gave us notice, everybody within that radius gave us a packet of notice. And they did on-site inspection of
Yeah.
our property if we
So
wanted
there's
it, so
someone
they
else
gave it.
on behalf of your company that takes care of that aspect of it as well.
Take a long vacation.
Okay, let's have one conversation.
Sorry.
That's all right. Okay,
Yeah,
any
I'm
other
gonna be
questions for the
inside.
applicant's rep? All right. Thank you, sir. Is there anyone from the public that would like to, please come up and state your name and,
Good evening. I'm Bob Castor. My wife Laura, with the glasses, and I are the owners of Lot 9, immediately abutting the construction site on the north. And I have two factual questions concerned with the documents that were submitted for this evening's discussion. One concerns what is mentioned about pre-blast and post-blast tests in the findings and in the approval conditions for the discussion tonight. Under findings, blasting ordinance 4.2, so forth and so on, is met since the applicant will conduct pre-blast surveys as required. pre-blast water tests have been completed. And I know that someone came to our house, videoed the entire exterior of the structure, videoed the entire interior of the structure, took a water sample. What strikes me about the language in this document is that it speaks about the pre-blast and, under the approvals, post-blast water tests. But it says nothing at all about the pre-blast and post-blast structural examination. And I think that needs to be specified.
Should be there.
Especially now that the number of blasts has been increased from 20 to 30. 30 blasts. My second question concerns the planning board application that was submitted for this discussion. If you have that before you and look at page 3, you will see excuse me while I do this, a Google Maps representation of where the blast site. And you'll see that on this representation, there are 2 circles. Now, what puzzles me about this representation is the fact that neither of those circles has a center that corresponds to what I assume is going to be the center of the actual blasts. The center of the lower circle is actually the existing garage structure on that lot. And I assume they're not going to blow that up. The other circle, the uppermost circle, the one that's closer to our structure, our house, the center of that is to the northeast of what I take to be the building site. So what I'm asking is, what does this representation of the blast site have to do with where the blasting is actually going to occur?
Can the applicant help with that one? Did he?
This is actually a pretty crummy image. I have a better image.
I noticed the 2 circles before, I wondered about that.
Okay. It's dark, screen's
Oh,
dark.
sorry. Wants Face ID, excuse me. Okay. There we go. This is where the site of the house seems to be. The center of the blast site is located either here or up here someplace.
So are you concerned that there is a structure that should be included in this?
I'm concerned especially that our structure, let me get back to the site. There we go.
Location of the blasting, not next to our house.
Yes, our house is right there.
Yep.
And if the site of, the center of the blast were represented on that image, it would incorporate the entirety of our house within the blast area.
As I read the requirements of the application in the blast ordinance, the
Yes.
250-foot radius circles are there in order to determine what structures that need to be inspected and which wells are located
Right.
within there. It has nothing to do with blasting of anything in that circle. It's to determine, this is in 3.2H, it's to determine what pre-blast assessments have to be made.
Yes.
In relation to what?
In relation to what? If the center of those circles is not located where the blasting is actually going to occur, what do they actually represent?
Is there any other structures that are within 250 feet of the area that's been cleared?
No.
When we went there, we couldn't find them.
Well,
We didn't see
There's-
any.
this neighbor right here
Right,
falls within
below
the lower circle.
Right.
We go out 300 feet.
I'm going to ask folks to come up to the microphone so that we can actually get
So
this on tape.
The folks that are home can see it too.
So we actually go out, I know you guys require 250, we go out 300 feet as far as pre-blasts and wells and whatnot. And a lot of times on the post-blast, I'm not sure what's in your ordinance, because every town has a different ordinance. I have a hard time keeping up with it all, but usually the post-blast, a lot of times you don't do a post-blast unless there's actually a problem. If someone complains there's a problem, then we'll post-blast. Or if someone wants it done, we don't have a problem doing it either.
I would like to see that language in the approval.
Well, it's not an ordinance, so it's something we don't have to do. I don't believe it's in the ordinance.
What the ordinance says is that the code enforcement officer makes that call. That he can determine whether or not you have a post-blast assessment.
At what point does the code enforcement officer get involved in this particular question?
If you make a call.
Okay?
He's involved in it throughout. He's the one that brought this to us.
I went through the
Code enforcement
blasting.
officer is the one who produced this document?
No,
No.
that was produced by
Oh,
our town planner.
okay.
Well, we're just asking that that condition be put on, that they monitor the structure as well as
The water quality. It seems pretty
What?
straightforward.
What say you codes?
Good question.
Must be cold back there.
It is.
It's ridiculous.
Hi, Margaret from the codes office. I don't know the size of the projects that you're used to doing, but in Harpswell, this is on the larger size, and I don't think it's unreasonable to require a post-blast water survey. However, there's no requirement for us to, there's no precedent for us to require a post-blast house inspection. That's all done through their insurance. And they have insurance and they provide copies of their insurance policy for this very reason. But we don't have any jurisdiction to make them do that.
Just as a matter of information, why would there be a requirement for water tests and not structure?
I don't know. I don't like the blasting ordinance, so I can't say. I don't think it makes a lot of sense.
But that's what the ordinance says.
Yeah, that's all we have the power to do, and we're happy to do it. And I don't know why you guys don't have the power to do it, because you're reviewing the application, but only the
But we're
code
not given
officer
the power.
can say that, so.
If we wanted to pursue this, how would we do it?
Pursue what?
Getting it made a condition of the approval of this project that structural as well as water post-blast.
We can't do structural, because it's not in the ordinance. If you ask them, they will do it for you. And it's part of their insurance, so, they have liability insurance in case there is any
So
issues.
if I contacted Joyce, would she be the person to?
The blasting company, I would imagine.
But what Codes is happy to require that. It's a bigger project for us, so I think it's reasonable. But they can't for whatever reason, because it's not in the ordinance.
Request codes.
Yeah, of course. Yeah, most definitely.
Yeah, we can't make it a condition of approval?
I think we have in the past. You guys have in the past, but it says, the ordinance says it's the code officer that can require it.
Well,
so.
the
do that
code
for Safe
officer
Harbor?
agrees, so
You need to come up here.
Oh, yeah.
Thank you.
I would just like to point out,
Yep, and state your name, ma'am.
my name is Laura Castor. I'm the neighboring abutting tenant as well, owner. I appreciate that people who own land want to use their land. I want to use my land. but this is an enormous project. This is 8,500 square feet. It's probably the biggest project in the area. And there are vernal pools. There are wetlands on this land. They're going to dump the blown up ledge into the wetlands and the vernal pool. And we have no drainage plan. We have no plan for any of the blown up pieces of ledge. We live on an island. This is going to impact our water. Our next door neighbor on the other side of this property has already had salt water infusion into their wells. He had to pay for an enormously expensive osmosis system in order to have any decent water. I do not want my water to be salt water. We have a well that works now. I'd like to have a safe water after this event. 30 blasts. Think about whether you want to be next to a place with 30 blasts. A basement that's 3,000 square feet. Why is that necessary? And I want to point out to you that there is currently an appeal for this building permit. How? How can you possibly authorize blasting while we have the potential of having the building permit reconsidered? This cannot happen in an orderly system. So where are the drainage, erosion, vernal pools analysis to begin with? This is much bigger than the project you just talked about. This is, many times the size of that project. They went to an enormous amount of effort to make sure that the environment would not be impacted. No effort is here. None. And it's quite concerning to me. I've lived in this house. We've had this house since 1988. It's a beautiful, small house, tiny compared to the incoming neighbor. The original plan for the construction had no dynamiting. It had the person who owned the lot and sold it to these people had a plan where it was just going to be drilling, no dynamiting. This is a very fragile environment. There can be cracks in the ledge. This is it's all ledge, what they're talking about. And they've already clear-cut in violation of what we had as easements, tree easements on the property. They've violated that. They've clear-cut the property. And there seems to be no attention whatsoever to the environmental needs of the community. And it's not just us that's going to be impacted. Yes, we're next door, and the neighbor on the other side or next door will both be enormously impacted. The drainage, the road may be completely washed out, our little dirt road that we all depend on to get in and out. We don't know that it's not going to be washed out. There's a big vernal area that's going to be filled in with the product of these explosions. This is unbelievable, actually, that somebody would come before you with so little support for our tender environment on Harpswell and ask to have 30 separate explosions. I'm asking you to please ask them for more information, ask them for a plan, ask them for drainage, ask them for an erosion plan, ask them about the vernal pools. Let's do this the right way, and let's not do it while there's a pending appeal.
I don't know about any building structure. I don't know anything.
Yeah.
Was at the site walk, so maybe it was talked. I don't know.
I thank you for your comments and totally understand where you're coming from. We have to work within the limits of the ordinance, which is, I know, really hard to hear, so let us do that. We'll do what we can. But your comments are they make sense.
Is
And-
the timing not an issue? If we have a current appeal, can you grant this while there's an appeal pending on the permit?
It's not appealed.
We don't know anything about an appeal.
Yes, it is. We filed with the Board of Appeal. Margaret can
For
confirm that.
reconsideration.
I'm sorry?
Reconsideration, they did not take any action the first time. Am I correct? This is the appeals board?
This is the Appeals Board.
When I looked at it, you filed for reconsideration of whatever action they took already, which was to not do anything. Am I wrong?
No, that's correct. We filed for reconsideration.
Right, but that doesn't stay the proceeding of what we have to do. This is a separate permit. That's the building permit. This is a blasting permit that is very narrow in terms of what we have authority for. But I
Well-
would like to discuss the earth movement part of this, because I think they do need to hear that part of it.
Thank you.
But that's up to you, Amy.
My conversations with Margaret, which I invite you to come back in from your cold office and reiterate, the board really doesn't have jurisdiction over what happens to that material. It's a codes issue.
I don't believe that,
Well,
and I'll show you why.
okay. This has been such an interesting meeting.
But I'm not.
No, by all means.
I'm not,
If I could just reiterate on some of her questions and concerns. You say 30 blasts. I mean, would you rather have 10 blasts? I mean, we do small shots, and that's why that 30 blasts is an estimate. There may be 20 blasts, it's an estimate on what's out there once they uncover it and shoot grades. And far as your well, I mean, most of your water is probably 200 or 300 feet down. We're only going 6 to 8 feet probably depth-wise. So we blast all the time around wells, and I ain't saying there ain't a concern, because there is, But I'm just saying most wells, the veins are down a lot deeper. And far as the number of blasts, we make small shots, keep our vibrations down. We shoot into relief, so you don't get much vibration. You might feel some air blast, but that's why we make smaller shots, and we cover it with rubber mats just to make sure there's no fly rock or anything like that. Thank you.
Thank you. Yes, ma'am. Please state your name and.
I'm Dee Dee Samay Miller. I live on Tote Road as well, a little further down. And, now I'm not even going to be able to speak. We were only made aware of this when the owner clear-cut the property that was right against the road. And you might have noticed that where you parked. That was all big trees that stabilized that area where the drainage for the whole, I think there's 6 lots. It all runs off the hill and it runs through there, and the trees help slow that down and keep it all nice. There were suspected vernal pools in there. It's definitely wetland, and you wouldn't have seen that because the day before we went to the appeals hearing, they pulled all the stumps out. They didn't do any erosion control until after that had happened, and we'd complained about it. Then they put wood chips around where all the drainage and some of the other vernal pools are. If you look at the way the water flows, like last week when we haven't had a lot of rain, but last week the water flowing through the Dinsmore property, I mean, that's his family home from, 40 years? How long did they live there? And he doesn't have the money to sue anyone. And he has to pay for that, and all that water flows through there. And if you see it right now, because there were no geologic studies done, there were no stormwater plans made, and everything that's coming off that whole property is not being slowed down where the trees were clear cut and it was stumped. and it's eroding as it goes onto his property. And there's no protection for him with that. There's no stormwater plan, there's no erosion plan. Blasting kind of changes everything. And I would think that you seem like you care about vernal pools in the environment. And it's like, but in this case, it doesn't matter because it's a single-family home. It makes no sense. You could have a home that's 1,000 square feet that has 2 families in it, and they'd have to do those kind of testing. And maybe that's not your purview, but it just doesn't make any sense. Because how do you protect the environment like that?
So,
I mean, this is Harpswell. I mean, we gonna just blow it all up and put mansions everywhere? It makes no sense. But
There's no wetlands on the property.
there's no wetland study done.
Okay, I'm going
You also
to,
covered that it's drainage.
can we have our conversation, sir? Thank you very much. Thank you. We just passed an ordinance that allows codes to hire outside expertise in order to ensure that construction happens as it is supposed to. Is that not true? Is that true, Margaret? Could you come up to the podium?
Yeah, I was at the last time in.
Yeah, the last
Yeah.
meeting.
We did, but it's through the site plan review ordinance.
Okay.
It's not, it's, because this is a residential project and not commercial, it's not subject to those standards.
So can we break this down into two
Yes, definitely.
two separate
Yeah.
categories, because the first is the blasting permit, which has technical requirements of how they do
Right.
notifications, pre-assessments, and the like. I noticed that the question was raised about a post-assessment water, and that, we already covered that in the conditions. It's already in condition 3, that there be a
Right, he was asking about the structure.
post-blast water quality. There is no provision for post-blast structure in the ordinance, so we cannot do that. So, except for what I think were a couple of deficiencies in the submissions, which have now been corrected by the emails we got and the oral testimony about when they're gonna do it and the hours of operation, it seems to me to be technically compliant with the ordinance. As to the blasting, I would have liked to have seen, to be honest with you, the property flagged or staked out so that we would know what the extent of the foundation is gonna be, but it wasn't done. We were there, it wasn't done. There's no way, there's a huge cleared area, and that's all we saw. That's part one. Part two is the issue of where they take the material that they blast. When I looked at the basic land use ordinance, because Tim and I had this discussion on site, and he said he was going to ask for more information about that. But, and you can correct me if you think I'm wrong, or Matt, you do this, but the land use tables, which are, what are the allowable land uses and activities in the basic land use area. As a matter of fact, it has all the districts, both the interior and the shoreline district. And 32 through 34 talk about filling and earth moving. And there's 3 separate sections with different who has jurisdiction. It goes under 50 cubic yards, 50 to 1,000 cubic yards, and then over 1,000 cubic yards. The one that says over 1,000 cubic yards, jurisdiction in all districts in Harpswell, including the interior, is with the planning board,
Interesting.
not the
It's
code
true.
enforcement officer.
It's true, yeah.
So if
That's why
they intend, and there is another section of the basic land use ordinance that provides that in filling and earth moving categories, section 15.16 of the shoreline zone, which sets out requirements for erosion control, sediment, all of the variety of things that we've been talking about, sedimentation studies, permanent stabilization structures, whatever, there's a whole list of things in 1516, earth moving, erosion, sedimentation control measures and additional measures to avoid different problems with, particularly with water and drainage. They are required to bring an application to the planning board before they do that. And I want to make certain, since they're not here, their representation, and that you guys will help us to
You
make
mean-
certain that that happens.
You mean if they're gonna,
If they're going to move
take
that stuff
yeah,
to their own property, if they're
Yeah.
going to truck it somewhere else,
Yeah.
that's not our concern.
yeah, I think that Tim will have a conversation with Turtle Lot Excavation about it and figure out what exactly the plan is.
What exactly the plan is, but then if they do intend to try to put it there because of the fact that there's water flowing through there, and it's a steep pitch coming down into that area, and they obviously cleared it for a purpose, we would like to be involved.
Of course, yeah. And it is some sort of stream, and I'm not sure what exactly the setbacks are from that stream, but it's possible that they need a permit from the DEP for the work that they did,
It
or,
depends on whether it's a stream.
right.
It's
But we're
very
happy to,
difficult
yeah,
to know
we'll,
that, but-
we'll look into it and
Would this-
definitely advise them with our findings.
Would this have to be done before the blasting starts then?
Only
In terms
if-
of finding the stream or whatever we're talking about here?
Only if they're gonna put blast rock there. I mean, they do have erosion control there, but yeah, it only depends on whether or not they're gonna fill in that area.
Well,
I thought that's what we heard.
It is what it's what Tim has heard on site, talking to some of the contractors.
Right.
But I don't know that we've heard that from the owners or from the excavators.
Right.
So it's all just hearsay.
So, this is another question, is there a written summary of what their plan for construction is?
Yes, they have a building permit, and we have all that stuff. There's not a written plan on what they plan to do with the blast rock, because they're not, typically, the excavators will take it off-site and resell it. Or use it on a different
So
project.
you've already given them the building permit?
Yeah.
Okay, and whatever appeal to the Board of Appeals, the building permit has not been stopped for any reason.
No?
No, it's really, I think, waiting on the blasting permit at this point. I think they've done everything they can do before they start blasting.
So how do we know for sure where that material's gonna go until it actually starts moving? We really don't.
We will ask them. And Tim and I both know that you have to get a permit if you're gonna fill in that area,
Right.
Okay,
so. We're on it, we're down there all the time, the abutters have called, the DEP, Conservation, the Harbor Master, the Code Office, now the Planning Office. Everybody's involved, everybody's had eyes on the project, Tim has been down there 100 times. Plus, there's lots of projects going on Gunpoint, and so we're down there a lot.
okay, so
We have close eyes
we've done
on
what we
it.
need to do to
Yeah.
ask you to help us get them to
Yeah.
hear,
Yeah.
And
if
if-
they intend to do that.
And
They
if you
intend
ask
to-
me at the next meeting, I can tell you what the answer is. What they ended up doing. If I don't, I don't remember to tell you before then.
Well, it would be certainly less expensive to take 1,500 to 2,000 cubic yards of material and keep it on site, but it can't be done in such a way that it affects the environment.
Yeah, of course.
Yeah, please. Remind me why. Yeah.
I mean, where he clear-cut those trees and then pulled the stumps, that's already affecting the flow of drainage through the Dinsmore property. It's a, I mean, I have pictures of it if anybody wants to see it. But, when this whole thing started, it was, I don't really have the date, but anyway, the bottom line is that the building permit was issued on September 3rd. It was supposed to be posted by 2 days later, I think is what the town said the rule is. And we never knew anything about it because it was never, the building permit actually wasn't posted until the day before the appeals hearing. That the blast permit was actually posted before the building permit was. The only way as people who live there that we could find out about the fact that there was a building permit issued was by them posting it, because the town isn't required to let butters know or anybody know. Like I said, the building permit was posted something like 53 days after it was supposed to. We were 3 days late filing an appeal, or whatever you call it, contesting the building permit. You know, I'd been down to the town office twice, and we had talked to the town office 2 or 3 times getting information. Nobody ever once told me that we had a certain number of days to file that. We never found that out until it was already 2 days late when Margaret told Laura. So the whole thing is just kind of bad for us anyway.
Yeah.
And I don't know what you can do or if you can do anything, but anything you could do so this doesn't happen to anybody else. It's just crazy.
It is crazy, and part of the, the challenge for us, as I think we really want to do due diligence. This project actually is large enough under our ordinance to sort of require site plan review. It's a big project, but it's a single-family house, so it doesn't. And so our hands are kind of tied, and Harpswell is really dealing with issues like this all the time.
Well,
And
this is going to be our future.
it is really difficult. It really is.
I just want to point out, there is a statutory provision, a state statutory provision. It's, I'll give you the citation in a minute. I believe it's chapter 38, section 420. It says, a person may not construct or cause to be constructed a project that includes 1 acre or more of disturbed area without prior approval of the DEP. A person proposing a project shall apply to the department for a permit using an application provided by the DEP, and it anticipates the very kind of studies that we're talking about for erosion, for vernal pools, and for stormwater flow. There is no exemption in that statute for a residential home. And I would point out to you that the size of this is bigger than most of your commercial applicants. And the environment doesn't really know the difference.
We understand. We understand.
Yeah.
But we don't have jurisdiction on that.
That's the DEP.
That's the DEP.
No, but if it's a violation, they have to apply for it before you can grant the building permit.
I'm not familiar with that.
I think usually it's like we refer to permit approval
By rule,
by rule, but we're not doing the building permit.
right,
So we can't make that clause,
yeah.
unfortunately.
Okay. Well, this kind of brings up something else, but this is more for a workshop discussion, and that is the town's attitude toward illegal cutting. We've talked about this before, and really going after folks that cut. And we have 2 people in the codes office. So it really depends on folks to let the codes office know. We depend on neighbors who call. And the town, if it's grievous enough, the town has taken significant action before. But it is 9:05, and.
But this isn't in the shoreline.
This is not on the shoreland.
The particular cutting along the road
Right.
is in the interior.
Right.
So I don't know whether
Oh, we've had issues in the interior, too.
I remember you mentioned some in the past.
Yeah,
Yeah.
definitely. Bethel Point Road and some other places. All right. Thank you for coming. Thank you for sitting through a lot of other prior stuff. Thank you for being concerned. I don't want the fact that our hands are tied to make you feel hopeless, and I can understand how it can. I do. You know, Harpswell depends upon people like yourselves who really care about the town, and so appreciate your concern. And you know, we're going to do our best, but we have a limited purview, so. Stay in touch with codes. Codes will stay in touch with us, and
Yeah, so Margaret back there, if you see something, get in touch with Margaret.
Margaret is.
You know, Ned said we could appeal, and it doesn't seem to be the case. So I don't even know what he was talking about.
All right, are we ready to review the findings and make a vote on the findings?
Yes.
All right. So let's look at conformance with the standards. To approve the application for a blasting permit for a, whatever that is, SHMGI project, single
Well,
house.
The Welch project at
Okay.
23 the Tote Road.
Yes. The planning board must find that the proposed activity meets the performance standards of the blasting ordinance. Here are draft, all right. So I will read the standards and then make a motion. Section 4.1 of the blasting ordinance, the application doesn't indicate it states. I think we need to, I want to just take some issue with that language, because if we approve these findings and the language is just that it indicates, what do we do if something different happens? So I'd like to insert states that blasting will be conducted between 8 a.m. and 7 p.m. as required by the standard. The board should
I thought
clarify.
you just said 3 o'clock.
7 p.m.
Because it depends on right now we're in winter, but in the summertime, so they have to have a
Yeah.
set timeframe. that
That's
they
why
can
I
follow.
asked the question about whether
Yeah.
blasting was ever done after dark,
Mm-hmm.
because obviously it should not be.
I believe that 4.1, where it says indicates, that is the ordinance itself.
That's the ordinance, but
So my language is
Thank
just
you,
what's in italics.
thank you.
Yeah, so we
Thank you.
cannot
That's,
strike that without changing the ordinance.
yeah, I'll have issues. Well, okay, we'll
That's
leave it,
That's a
but
workshop question.
Yeah,
Yeah.
okay, thank you. All right, the application indicates a blasting will be conducted between 8 a.m. and 7 p.m. as required by the standard. I move that the planning board finds that standard 4.1 of the blasting ordinance is met, provided that blasting is limited to Monday through Friday. The applicant state that the blasting will occur between the hours of 8 a.m. and 6 p.m., so that handles it. Section 4.2, I move that the planning board finds that standard 4.2 of the blasting ordinance is met, since the applicant will conduct the pre-blast surveys as required. Pre-blast survey, water tests have been required, as have pre-blast structural surveys.
Completed.
Yes, have been completed, as have pre-blast structural surveys.
We're adding as,
Adding,
Yeah.
yes, as have pre-blast structural surveys. Thank you. That's to 4.2. I move that the planning board finds that standard 4.3 of the blasting ordinance is met, since drilling and blasting rock specialists has stated that all blasting will be done in conformance with these technical standards, and that the required records will be maintained. There's a motion on the table. Is there a second? Second? Thank you. Any discussion on the motions? All right. All those in favor? All right. Thank you. Dan, do you want to do conclusions of law?
Sure. I move that in light of these facts, with consideration given to the supporting documentation in the record, that the planning board reaches the following conclusions. The planning board finds that the applicant drilling and blasting rock specialists on behalf of the owners Jerry and Ruth Welch have met the standards of the town of Harpswell blasting
Ordinance, yeah.
The planning board approves the application for a blasting permit to remove greater than 300 cubic yards of material by approximately 20 blasts.
30 blasts.
30 blasts.
So that has to
On
be,
map, 48 lot, map 48 lot 48.
That's the wrong numbers.
Hmm?
That's the wrong numbers. Typo.
Yes, it should be 3913
Yeah, because that's what it says on the front page.
3913?
for map and lot number.
lot 39, map 13.
Yes.
Yes.
On map 13, lot 39.
All right, let's try that again, just to make sure we've got it correct.
It's map 39, lot 13.
Good grief.
Yep.
Okay,
Lot
the planning
39.
board finds that the applicant drilling and blasting rock specialists on behalf of the owners, Jerry and Ruth Welch, have met the standards of the town of Harpswell blasting ordinance. The planning board approves the application for a blasting permit more than 300 cubic yards of material via approximately 30 blasts on map 39, lot 13. As
Well,
conditions.
Okay, this is wrong, and the background says lot 39, tax map 13, which is right?
3913.
39.
Lot 39.
Right.
Okay, okay. God, it's late.
All right, conditions of approval. The applicant must provide a pre-blast assessment for the requirements of section 3.2 H.A. and B at the time the permit is granted by the code enforcement office. No blasting shall occur before 8 a.m. or after 7 p.m. on weekdays or on weekends or legal holidays. 3, post-blast water quality test shall be conducted on any wells that had a pre-blast water quality test unless the property owner notifies the code enforcement office that they do not want a post-blast test. That's the motion.
Second, the motion as amended. Any discussion? All right,
All-
go for it.
All in favor? Motion passes. Thank you. We were
Thank you.
limited with what we can do here.
I just think the town really needs to rethink this process.
Oh, my friend, you have no idea.
Well, that is-
We have probably got 3 years of work to do on really looking at these kinds of issues, you know.
And that's the reason why we have embarked on this whole comprehensive plan, is to give us a framework from which we can continue to isolate these things and deal with them.
No changes in the shoreline zone.
Yeah, right.
Same thing happened at the appeal board, it was the same kind of thing. It was
Comp
just
plan's
a
not
law.
gonna change that.
No, it's not gonna do it.
And a lot of the other communities are going through it too.
It's frustrating to us, too.
You guys do have one of the toughest ordinances as far as blasting, just to let you know.
Oh, thank you,
Cover the whole state, and you guys cover it pretty good.
thank you, thank you very much.
Still doesn't
Okay, let's see, we have the rest of the meeting to go.
Other business.
Other business, consideration of minutes from the November
Thank you
20th
for coming, though.
and 25th, 2024 meetings. I was not there, so I have no say. Has anyone read those minutes?
read them.
Want
Yeah, I
to
think
take
they're
this
good.
up?
Yeah, the November 20, I have to find the November 20 minutes.
I looked at the 25 ones, I didn't.
The 20, November 20 minutes are accurate,
Yep.
except on page 13, Remember there was a whole thing about the cut and paste, and there was stuff about the wharf,
Mitchell
Okay,
Field,
bye-bye.
yeah,
the wharf?
yeah, Mitchell, yeah,
The
the
Mitchell
wharf at
Field
Mitchell
stuff?
Field was there.
There's one place, did you get a chance to look at that?
Yeah, I had already taken it out of the, it was highlighted in yellow when I sent it out to you guys, I think.
Right,
Yeah, I had already taken it out of the NOD, I just hadn't taken it out of the minutes yet.
okay, so
It's
the,
gone,
so the part that was highlighted in yellow is gone?
gone.
Oh, okay,
I just forgot to change it before I sent it out to you.
okay.
I highlighted it so I would remember to change it.
Nothing else to
Instead,
do.
you brought
I
it to Dan's
wanted-
Do you have
attention.
nothing
Yeah.
else to do?
Because it was in bright yellow.
Yeah, well, it's hard to, yeah, okay.
Okay, all
With
right.
that being removed, I have no changes, additions, or corrections to the minutes.
And I was not at the October meeting, so I can't read on that one, so.
Okay.
Well, we're just,
You get to vote
we're
even
looking
though you
for
weren't
November.
at the meeting.
Oh, yeah.
Okay, no
Okay.
changes, okay.
Okay. I
Wanna
move
make
that the
November, never mind.
minutes of the November 20 and 2024 meetings be approved.
Second.
Sounds good to me.
Third.
All quick.
Any discussion, all in favor?
Okay,
I
good.
Passes.
All right, planners update.
Yes, well, first, as you know now, probably, tonight is my last, well, this is my last day. And once I go home from this, unless you keep finding stuff to talk about, I'll be gone. So, thank you for making it a nice, over 10-hour day for me. I appreciate that.
That's hurrah, man.
Yeah.
Had to go out with a bang. So I thank all of you for some good discussions and challenging questions that have been posed throughout the past few months. There's been some really interesting applications that have come forward, and I thank you all for your support in trying to get them approved, denied, or tabled, or whatever they may have, whatever the result may have been. Anyway, we have, I'm not going to pretend to remember all the dates off the top of my head. We do have a series of workshops coming up. We are trying to get these these new RP maps settled, and Judy is diligently working, I hope, still on those to try to get them to us. Margaret, would you like to take over for that one?
Yeah, she emailed me today. She said she'd
Okay.
have them by end of business today, but, or end of her work day today, whenever that may be. So we have the maps coming. It's very exciting because we've been waiting a long time. Judy's made all of the changes that bring the maps into alignment with the DEP regulations for shoreline zoning. But there's still some work that I think that we can do. Some technical decisions that she made that we can review together. And my plan is that Monday, the 30th, we'll look at the maps. Everybody can have digital copies, paper copies, whatever you want. You can take them home, mark them up. And then the next Monday, we'll finalize any changes. And then I have to get all the changes done by the next day by Judy, because there's really strict noticing guidelines. If we're changing, if anybody's property is going into the RP district, then they need to be notified by mail 14 days before the public hearing. So it's just really strict, really,
Redoing the public hearing?
yes.
And it's just strictly for that issue.
Or whatever other ordinance amendments. We're still waiting on feedback about the definition of commercial fishing. So that should be on there. There's some shoreline, there's a little bit of shoreline zoning verbiage that'll change about the flood zones.
Who are we waiting to hear back from on the commercial fishing definition?
Amy Chow.
How is she gonna hear back? We have no money for her to contact us.
She's supposed to hear, we're supposed to hear back from her by the beginning of next week,
Do we pay for it?
or by the beginning of January.
That's what sucked
So
up all
there
the
was
money.
nothing
Yeah.
for the fishermen.
Yeah, we
on
burned it, Dan, didn't you? Our definition burned through the budget.
No, I think it
Probably
was,
broke the budget, that's
Yeah.
why we had it.
Yeah.
My
I think
wife
it was the
said
codes
too.
office, guys. I think it was the codes office and this Board of Appeals thing for 28 Field Road.
Yeah, I had a
I
feeling
think we
that came
sucked up all your
Yeah.
budget.
What road?
What is
28
the,
Field
i-
Road.
is that, what is the
You know,
Board of
really,
Appeals
really
gonna do on this
Oh, I
next?
know too well.
Have they
but-
got it scheduled on their meeting?
Yes, next Monday. It's,
It's
yeah.
next Monday?
So it's just a request to reconsider.
All right, so we've got a workshop on the 30th.
And then a workshop on the 6th.
It's the
Then,
Okay.
so 2 Monday meetings, because some of you weren't available on Thursdays, which is fine. And then the regular meeting, I think, is on the 15th.
I think so.
And then we're gonna do a public hearing on the 22nd, because we couldn't, even if we had time at the regular meeting, we wouldn't have time to notice people in time.
I won't be at the next regular meeting, but.
Have you given us a calendar for 2025 for planning board?
No,
Okay.
I have not, and it's not on the website yet, but it is done,
Okay.
Okay.
yeah.
Sooner the better, if you could just get that out.
Those are 4 o'clock,
I didn't
right?
copy down.
Yeah, I was gonna ask you guys what time you want the public hearing on the 22nd. Do you want it at 6:30, like a regular meeting? You can have it
Yeah.
whenever you want
6:30 is
it.
fine. Yeah.
It's easier to keep it consistent.
Okay.
Monday, the 30th,
Yeah,
6:30.
4 PM,
How,
No, 4,
4 PM.
What, on the 30th, you said?
yeah,
12:30 and January 6th at 4 o'clock,
the workshops.
the workshop.
4 o'clock.
And then the
Didn't you
regular,
send this out in an email?
Yes,
Mhm.
it's in
Okay,
an
good.
email.
Yeah.
Good,
yeah,
because
she
I'm
did,
like,
she did. My
Yeah.
concern
Not even in
about
the
these
right year.
maps is that I don't know whether they're accurate or not.
they're
Yeah.
gonna be accurate as far as, what I really want help reviewing, and you guys don't have to help me, I don't know the process, so just doing my best. But it's supposed to be, the rule is 1 principal structure for every 1,000 feet, really. But Judy has no way of knowing if it's a principal structure, or a fish house, or a barn, or garage within the shoreline zone. So I'm just hoping that together we can review this map to make sure that only principal structures are included in this 1,000-foot buffer. That's what I think we can do.
I mean, it, I think,
Or I can do it, or,
no, I
Yeah.
mean, really,
Is this a Google Earth thing, or is it
it would be like going through the assessing records, I think, looking at the assessor.
the property
be more
owners
accurate.
themselves are the ones that would know. So the key is to get the notification out for people so that they can come and check their own property.
Yeah.
That's really the key. That's what, because otherwise folks are gonna get surprised down the road. But we'll do what we can.
do you remember when she said the public hearing?
Ideally, I was thinking that we would know the answer to what the structure is before we send out the notice.
That would be nice.
You know, and it doesn't affect that, it's only gonna affect certain properties that have structures in the shoreline zone and out of the shoreline zone, to figure out which one is, where their principal structure
I found
is.
it today when I was looking.
All right.
So,
Couldn't find.
it'll be interesting.
Thank
Do
you.
you have a rough idea of how many properties it's going to affect yet, by any
No.
chance? No.
Mm-mm.
Okay. All right.
But as soon as I get the map, I'll send it out to you guys so you can start poking around.
Okay,
Thank you.
okay.
Did you put
Right.
December 30th?
All right, anything else?
Jan 6th at
Yep.
4.
It was the public hearing.
Okay.
I was just wondering with this tow road thing, how big is that single-family home? I was just wondering.
huge?
think
How
the
many square feet?
8,000.
8,000, but the footprint is like 1,200,
What?
right?
So it just goes up?
It's 3 stories, I think.
Well, we couldn't tell because of the,
Yeah, no.
They didn't
no
mark
way.
Anything.
That's how they
3
go.
stories, but it's not going over
Wow.
30 feet.
I can't even.
No, it's
that's
because they're
bigger
gonna
than-
blast, so they're gonna sink
That's
down the
bigger than
It's supposed to
basement.
be sub-level, like a
Well-
walkout basement.
Big.
If you can get it, yeah.
No
So I
kidding.
can't, 8,000? How can that?
This bugger shade.
We need to put
dry AMD,
a limit on the size of houses.
sure,
She waves her wand.
sure.
$9,000.
I mean, come
I
on.
believe it.
That-
It's good.
No, yeah.
Adjourn.
Thank you. Okay, we're adjourned, sorry. That was probably.